on the lunch.
I'm ready, Judge.
All right. Good morning. Is this David?
Yes, Judge.
All righty. Thank you very much. We are going to begin this morning, notwithstanding a few challenges. First and foremost, that very noisy fan that we're hearing. The board administrator is making contact with the facilities folks to try to get that turned off. So let me start back at the beginning. My name is Felicia Orth, hearing officer appointed by the Environmental Improvement Board to conduct a hearing in the matter of proposed adoption of 20.2.92. Stuart, you can't hear? Oh dear, okay. I really hope they get this fan off. All right. In the matter of proposed adoption of 20.2.92 of the New Mexico Administrative Code, Clean Transportation Fuel Program, docketed by the board administrator as EIB 25-23. We do have an interpreter here in the event anyone would like interpretation between Spanish and English and Spanish. Ms. O'Grady, would you please make an announcement?
Yes, Madam Hearing Officer, good morning. If there is anybody that would like to listen to the proceedings in Spanish, please come forward and we'll give you the earphones so that you can listen to the interpreters online. If there's anybody who is online that would like to listen to the Spanish, you'll need to go to the bottom left-hand corner of your screen, click on the globe and choose Spanish. Then you can move the bar all the way over to interpreter and you'll only hear the interpretation. Buenos días a todos. Si hay alguien aquí presente que quisiera escuchar la interpretación al español, pueden pasar adelante y con mucho gusto les entrego unos audífonos para poder escuchar. Para los que están en línea, también ustedes pueden acceder al canal de español. Si miren en la esquina, abajo a la izquierda, ahí hay un mundo, nada más tienen que hacer clic, escoger español y luego pueden mover la barrita para escuchar más el inglés o el español. Thank you. Gracias. Oh, and if there isn't anybody that needs or would like to listen to the interpretation, we can use these devices for hearing assistance as well. So if there isn't anybody that needs the interpretation, I'm happy to give you the headphones so that you can hear in English.
Thank you very much, O'Grady. So just a few preliminary things, and then we'll get started with the evidence. I'm joined by at least 4 of our board members. The chair here is to my right, Chair Sweeney. Member Ely is to my left. We have Member Garcia, Member Hunker, and perhaps Member Bitzer online. We have already had the first 2 weeks of this hearing. That was the direct case, with the exception of Growth Energy's witness. We will hear from Growth Energy's witness and then leap into the rebuttal case. There have been a lot of filings. You can see them all on the Docketed Matters webpage for the Environmental Improvement Board. Due to some technical and other logistical difficulties, was not able to write up the things we agreed upon or that I decided in our most recent pre-hearing conference last week. But let me share with you what I remember. and took notes on. We will hear from Dr. Brown first. And Mr. Nasco, do I understand that, do I remember you haven't made your opening statement yet, have you? Okay. Okay, so we'll start there. We'll hear from Dr. Brown. And we have a request to hear from Mr. Moody between no later than this afternoon. That is AFPMI's witness. We will proceed in the reverse order from the order of testimony that we had on direct. Meaning we'll hear mostly from industry parties before pivoting toward the petitioner. Cross-examination will also proceed in reverse. The time on rebuttal is shortened a bit. What I see in the pre-hearing order, please correct me if I'm wrong, counsel, is that each witness still has 30 minutes to summarize their pre-filed written testimony, but then cross-examination is limited to 15 minutes per party and redirect is limited to 10. I hope that comports with everyone's understanding.
Madam Hearing Officer.
Ms. Zona.
Thank you. So 2 points of clarification from the information you've shared. Following Growth Energy, the parties agreed that NMED's witness, Colin Murphy, would go, and then AFPM's witness, Mr. Moody, would go. And so there was that additional change to the order you shared. And for rebuttal, I believe your pre-hearing order says 15 minutes for presentation of oral testimony and 15 minutes for cross and 10 minutes for redirect.
Member Ely is showing me on page 3 exactly where that is. Thank you so much. Let's see here. So the hearing is being recorded and transcribed by David Lee of Cumbre Court Reporting. A few important things about that. We will need to speak into the microphone, every one of us. We will need to speak slowly and as clearly as we can. Please anticipate that we'll be taking breaks about every 90 minutes. Even if that means that, well, with a 15-minute witness, I guess I don't have to interrupt you. We will also take a lunch hour, and we will do our best to be out of this room not long after 5 or by 5. Tonight is the last of our evening public comment sessions. It'll start at 6 and it will be virtual. Is there anything else we should talk about before we go to Mr. Nasco for his opening statement? No? Oh, Mr. Ugarte.
Madam Hearing Officer, could we just confirm, maybe with Ms. Jones, that the link for the public hearing or public comment tonight, is it a different link or the same link? Okay, thank you.
We learned that the hard way. All righty. In that case, if there's nothing further, Mr. Nasco. Oh.
Graham Noyes for Infinium.
So,
Thank you, Madam Hearing Officer. Graham Noyes for Infinium. Wanted to ask a clarifying question. Would it be possible for someone to read out the actual sequence of the parties when we say reverse order, what that means, so we can be sure to be ready at the appropriate time when we have the opportunity for either witnesses or cross-examination?
Yes, sir. Thank you. That's a great idea. So again, setting aside the exceptions we have already identified, it would be American fuel and petrochemical manufacturers, Oxy, Maxwell, HF Sinclair, NMOGA and API, Coalition for Clean Affordable Energy, Rio Valley Biofuels, National Sorghum Producers, Growth Energy, GEVO, Next Renewable, and World Energy, also SAFCO, Verde Clean Fuels, Infinium, and the New Mexico Environment Department.
Thank you, Madam
Madam-
Hearing Officer.
Ma'am, yes.
Madam Hearing Officer, did you have on your list the Coalition for Renewable Natural Gas?
No.
If I may suggest, we put them either before or after Rio Valley Biofuels. Mr. Sorayas or Mr. Wade may have an opinion, but I believe that would be an appropriate placement for their rebuttal testimony.
Thank you very much, Ms. Sona. Coalition for Renewable Natural Gas. I'll put them after the Coalition for Clean Affordable Energy and before Rio Valley Biofuels.
And Madam Hearing Officer,
Yes.
this is Tyler Lobdell on behalf of Food and Water Watch, and I apologize, I was not able to attend the pre-hearing conference due to an unavoidable conflict, but I do intend to potentially engage in some cross-examination this week, so I noticed that we are also absent from that list. I believe you had us right after CCAE in the prior order, but I would be amenable to any slot.
Actually, so I have two different lists. Mr. Noyes asked for the order of presentation.
Presentation, I'm sorry. Okay, thank you for that.
The list for cross-examination you are on. You're right there, number 6, in the usual order.
Thank you, Madam Hearing Officer. One other point, if I may, just to clarify so I understand. My understanding of the initial pre-hearing order was that there would also be a public comment period today at 1. Has that been moved to 6, or will that also be an opportunity?
No, there will also be one at 1.
Okay, thank you so much, Madam Hearing Officer.
All right, anything else? Oh, I see Mr. DeSalen on his feet.
Good morning, Madam Hearing Officer and members of the board. I just want to mention that our witnesses, we have 2 witnesses, do have some scheduling conflicts. As best as we can tell, it looks like we will be going on Tuesday afternoon, maybe going into Wednesday morning. And those are good times for us. But if we get away from that time slot, we may want to take our witnesses out of order.
Okay, just to remind us when you detect that we need to alter our path, if you would.
Yes, we'll do that. Thank you very much, Madam Hearing Officer.
Thank you. Anything else at all? All right, great. Mr. Nasco.
Good morning, Madam Hearing Officer and members of the board. My name is Tom Nasco. I represent Growth Energy. And we have a very brief opening statement because our issue is not really a heavy lift. What we were asking the board to do and the hearing officer to recommend is that this board adopt the emission factors for indirect land use changes for corn ethanol that align with the most recent version of the Argonne National Laboratories Research and Development GREET model. Now, the NMAC is proposing the CARB figure for indirect land use changes, which is really based on data from 2014 and previously. It does not incorporate the newer data. There's been a lot of iterations to the model that have occurred, and the modeling that the NMAC is proposing in this instance, as our witnesses will describe, really is obsolete. It does not take into account data generated in the last decade, which shows that unequivocally the indirect land use change from corn ethanol is much less than the value is much less than that proposed by the NMED. So we are asking that the board align itself in the rulemaking procedure with what the federal government has adopted under the Biden administration for the credits available for indirect land use changes, and what the state of Oregon has recently adopted. Now, these are different than the CARB adoption of the data from 2014 because they're based on the iterative process of modeling, which incorporates new data, which gives us more comfort and more security and more certainty in the type of land use changes that actually occur from the displacement of cropland. And Madam Hearing Officer, members of the board, today we're going to present in support of our request Dr. Tristan Brown, who is here and ready to testify. And what I propose doing for matters of expediency is to have Dr. Brown summarize his direct testimony, after which have him summarize his rebuttal testimony, and then have him submit the cross-examination, rather than breaking it up in a cross-examination for direct testimony, then rebuttal. And I've spoken to Ms. Sohn, and I believe she's in agreement that that's probably a more efficient way to proceed.
I agree with you.
Thank you, Madam Hearing Officer. Your Honor, Madam Hearing Officer, members of the board, we would call Tristan Brown as our sole witness.
Thank you. Dr. Brown, would you please spell your first and last name?
Yes, first name Tristan, Tristan. Last name Brown, Brown.
Do you swear or affirm to tell the truth?
I do.
Thank you.
Would you state your name for the record, please?
Tristan Brown.
Dr. Brown, what is your profession?
I am a professor of energy resource economics.
And where are you currently employed?
I am currently employed at the State University of New York's College of Environmental Science and Forestry.
And where is that located, sir?
Syracuse, New York.
And would you describe for the board your educational background, please?
Yes, I have a JD from the University of Missouri. I also have a PhD in biorenewable resources and technology from Iowa State University.
And what is the purpose of your testimony today, Dr. Brown?
I am here testifying in support of Growth Energy's proposed corn ethanol indirect land use change value of 6.1 grams of CO2 equivalent per megajoule.
And Dr. Brown, would you briefly describe for the board and the hearing officer your experience with analyzing low carbon fuel policies and indirect land use change assessment methodologies?
Yes. So in 2009, I was employed as a research associate at the Center for Agricultural and Rural Development at Iowa State University in their Department of Economics. In 2010, I was deployed as a research associate in the Department of Economics, working on agricultural economics, agricultural policy issues. I then was employed as a research associate at the Bioeconomy Institute.
Slow down a little bit.
All right.
In 2010, I was employed as a research associate in the development of economics working on.
Sorry, let me start that over much slower. I was a research associate at the Bioeconomy Institute, where I was employed from 2013 2014. In 2014, I joined my current academic institution as an assistant professor of energy resource economics. I was employed at that level until 2019, when I was promoted to an associate professor of energy resource economics. And as of August of this year, I am now a full professor of energy resource economics.
Dr. Brown, have you filed direct testimony in this case?
I have, yes.
And do you have any changes to be made to that direct testimony?
No,
And do you adopt that written testimony as your testimony today?
I do.
And Dr. Brown, would you please provide a summary of your testimony for the board and the hearing officer?
Happily. Madam Hearing Officer, members of the board, thank you for having me here today. First, I will provide a brief narrative description of how early modeling on indirect land use change, which I will be referring to as ILUC or ILUC, of crop-based biofuels was conducted by the California Air Resources Board which I will refer to by its acronym CARB, to generate the ILUC estimates that NMAD is proposing to use for corn ethanol. Then I will detail the iterative process of ILUC modeling critiques and improvements that have occurred over the subsequent 11 years since the values that NMAD is proposing to use were first calculated in 2014 and later adopted by CARB in 2016. However, because those values were calculated in 2014, I will from this point forward refer to them as CARB's 2014 values. I will discuss how this led to the development of the C Club model, that is CCLUB, stands for the Carbon Calculator for Land Use Change from Biofuels Production. This is a land use change emissions factor model, which was developed as a replacement for the now obsolete AEZ-EF, which is short for Agroecological Zone Emissions Factor model, that was used by CARB in 2014 to develop the ILUC emissions estimate for corn ethanol that NMAD is proposing for use today. After that, I will show that New Mexico's proposed ILUC values for both crop-based biofuels and corn ethanol specifically are much higher than those found in modeling estimates from the last decade. Finally, I will recommend that New Mexico align itself with the federal U.S. government by deriving a Clean Fuel Transportation Program corn ethanol ILUC value of 6.1 grams CO2 equivalent per megajoule from the most recent version of the GTAP Bio, which is short for Global Trade Analysis Project, plus C Club modeling framework, which I'll refer to as the C Club modeling framework for short. I'll explain how such an alignment would minimize distortions between the program and similar programs and other programs that utilize or can be expected to utilize the most recent modeling to produce ILUC estimates, and to reduce compliance costs under the program by enabling crop-based biofuels to receive fuel credit for the emissions reductions that are calculated. In other words, Madam Hearing Officer, members of the board, I will explain how NMAD's proposed use of an obsolete ILUC corn ethanol value will unnecessarily place the Clean Transportation Fuel Program at a disadvantage that could be avoided through the use of the federal government's more recent ILUC modeling. ILUC is a relatively young field. This was not something that was really analyzed prior to 2008. In 2008, we saw really the introduction of one of the first ILUC modeling efforts, and this was specifically focused on calculating ILUC values for corn ethanol. Was an analysis that was actually conducted by my former colleagues at Iowa State University's Center for Agriculture and Rural Development, along with co-authors and a lead author from outside of that institution. Between 2008, when that first seminal study was published, and 2014, when CARB ultimately calculated the values that NMAD is proposing to use today, very substantial changes were made to the initial analysis. But this was still a very rudimentary field. We did not have that much in the way of dedicated models that had been built from the ground up to calculate ILUC values. We did not have much data to use within the models that was based on what's actually happening on the ground. And so many of the values between 2008 and including in 2014 were forced, simply due to a lack of data, to use assumptions. And many of those assumptions were used in a way that made them very conservative. There was recognition that there was a great deal of uncertainty, and there was a lot of concern that we in the US would be using biofuels that could actually cause higher than expected greenhouse gas emissions. And so the precautionary principle very much applied to those early models in adopting values that ultimately were, in retrospect, on the high end due to this concern. California, when it was standing up its low carbon fuel standard program, led one of the first major modeling efforts to calculate indirect land use change values for multiple biofuels, not just corn ethanol, but corn ethanol is what I'll be speaking to today. And to do this, they developed, or they took an existing model called the Global Trade Analysis Project Model, GTAP, what's commonly known as GTAP Bio, combined it with the AEZ-EF emissions factor model to calculate how increased demand for biofuels in California would change markets, supply and demand, not just in the US, but around the world, and how those changing supply and demand dynamics would affect prices and ultimately production of feedstocks for crop-based biofuels around the world. And these values were used to make the estimates that were first released in 2014, that CARB adopted in 2016, and that in unchanged form from 2014, NMED is proposing to adopt today for New Mexico's Clean Transportation Fuel Program. A lot has changed since 2014. And you know, this is ultimately when it comes to ILUC modeling, because it was such a young field in 2014, we have seen major modeling efforts, major data collection efforts going on, not just in the US, but around the world. And so whereas CARB's 2014 values at the time represented the state of the science, much has changed in that state of the science over the subsequent 11 years. And so by proposing to adopt CARB's values that were first calculated in 2014, NMED is proposing to, I would say, ignore what is today the state of the science by utilizing what was the state of the science 11 years ago. To understand just how much has changed, though, really want to focus on three key areas. And this is something that we have seen efforts in the US, we have seen efforts around the world to develop not just better assumptions for use in ILUC models, but increasingly to collect ground truth data to show just what those assumptions would more realistically be. And this has been a major effort, especially in the US, because the federal government has been supporting this process through Argonne National Laboratory, which is the national laboratory that has developed and is continuously updating the C Club model that I referred to earlier. And the C Club model has been developed in response to the growing recognition that the AEZ-EF model that CARB used in 2014 no longer reflects the state of the science, no longer reflects what we're seeing on the ground. So three big areas I want to focus on. The first has to do with how we determine how much carbon is on the land. And this is commonly referred to as the carbon stock, the land carbon stock, which is a bit of a complicated way of just saying there is carbon on the land in the form of biomass. There is carbon below the land in the soil carbon, and then biomass that is below the ground, the rootstock of plants. When you convert land from one use to another, but especially when you convert land to agricultural production, you lose some of that carbon. Any biomass that is growing above ground has to be removed. Much of the soil carbon below ground is exposed to the atmosphere where it can oxidize through biological processes. And this is fundamentally what ILUC is focused on, is trying to estimate how much carbon is lost from the land and converted into greenhouse gas emissions that go to the atmosphere due to land use change resulting from the production and use of crop-based biofuels. The AEZ-EF model that California used in 2014 based its estimates on how much carbon was on the land using what is referred to as the IPCC, that is short for Intergovernmental Panel on Climate Change, which is, you probably heard a lot about right now because of the COP30 conference in Brazil. They're really the leading authority on just about all things climate change and greenhouse gas emissions. They had developed factors, really in an inventory, carbon stock inventories in 2006. Those 2006 inventories are what California used in 2014 and what New Mexico is proposing to use in 2025. IPCC has not stood still though. And in 2019, IPCC released new values that contain some really large changes to what we believe we know about the carbon stock on the land. In some cases, they revise the estimates higher. They believe that certain types of land have more carbon than was previously believed. But in most cases, and especially in those cases where we are discussing land that is considered to be at risk of land use change, they have revised the figures lower, in some cases by as much as 80%. C-Club utilizes the 2019 IPCC values. And so that's one major difference between what C-Club does and what New Mexico is proposing to do. One of the studies that I cited in my direct testimony, and NMED was kind enough to actually introduce that as Exhibit 139-D Delta, shows just how much that change is. And so I'd invite you to look at Figure 3 in that exhibit, which is a figure that is showing the changes and specifically the reductions that have occurred. And so because of those reductions, the original AEZ-EF model was really focused on percentages. Because we didn't have a good understanding as to how much carbon was lost during land use conversion, that particular emissions factor model tended to use percentages. Well, a percentage of a large number is going to be a bigger absolute value than a same percentage of a smaller number. And so what this means is just due to that one change alone, and this is what is demonstrated in NMED Exhibit 139-D, ILUC values for corn ethanol in particular have come down just taking that change. So that's the first major change that's occurred. The second major change is we've developed a better understanding as to just how much soil carbon is in the types of land that are at risk of being converted. This is taking place both domestically and internationally, but domestically is where we're seeing the largest amount of research being done. And there's one type of land category in particular that C-Club has been making constant iterations to. And this is what's referred to as cropland pasture. Cropland pasture is land that is being converted repeatedly between cropland and pasture. Historically, we would normally think of the most land being at risk as pasture or grassland that would be converted to cropland in order to support biofuels production. But marginal lands in particular often bounce between the two. And this is something I've seen repeatedly during my years in the field, is marginal lands will be used to produce corn when corn prices are high. And then when corn prices are not high, it will be allowed to lie fallow, and it will ultimately be reverting back to pasture. And so that's what this land category is focused on, is land that goes between the two rather than consistently staying in one area or the next. In 2014, the AEZ-EF model used an assumption that cropland pasture land that was converted to cropland resulted in 50% of the emissions of pasture that was converted to cropland. Well, over the last 11 years, there have been a number of studies, including soil carbon analyses, surveys of the land, cropland pasture, that sort of thing, that have ultimately determined that this 50% value is not all that realistic today, especially on average. And so this is what C-Club also does, is C-Club is constantly taking the new data as it comes out on cropland pasture emissions and building that into the emission factors, replacing that what is now a rudimentary 50% assumption that was employed by the AEZ-EF emissions factor model. The final major change that we have seen over the last 11 years is we have a much better understanding of corn production systems, both in the US and worldwide, than we did back in 2014. In 2014, and especially in the lead up to 2014, the general assumption was that we had basically tapped out corn yield increases. We had seen major increases in corn production yields, especially during the 1960s, the 1970s, the Green Revolution. And the general expectation, especially with concerns about the changing climate, was that we would not see corn yields increase. And if we couldn't increase corn yields in the US, even as we were increasing corn ethanol demand, then we would have to convert more land to corn production in the US, which is the domestic type of indirect land use change that's generally being worried about. That hasn't happened. We have actually seen corn yields continue to increase. I wouldn't say they've been drastic increases, but when you look at especially the earlier studies, 2014 and earlier, on indirect land use change estimates for corn ethanol, they were predicated on 0% yield increases for corn moving forward. And I'm going to attempt to pull up my demonstrative exhibit and share that. So if you give me just a moment here, so I can show you what I'm talking about. All right, here we go. I believe that worked. I can go to the next one. Yeah, so what I'm showing is a comparison of US corn acres harvested and corn yields since 2000. And starting in 2013 was the general expectation that our corn yields had peaked and they were not going to continue to increase. They have increased, and so that has really helped control the amount of corn acres harvested that we have seen. Now, something I should note with this figure was based on an April 2025 USDA report. 1 week after the filing deadline for this particular demonstrative exhibit, the USDA released data through 2025. And at first glance, the 2025 data appears to show a major spike in corn production. And I just want to note that is a direct result of the current trade war with China in particular. That spike is almost completely offset by the concurrent reduction in soybean acres. And so what's really happening here, most farmers that use or grow corn and soybeans do so on a rotation. And so when the soybean market disappeared last spring, they quickly made the decision to grow corn instead of soybeans. So even though it appears to show that we are increasing corn production land use in the US, I just want to note it's not an increase to overall crop production, especially between corn and soybeans. Now let me switch back real quick, please. So what that ultimately means then is you put all three of those together, and the inputs to our indirect land use change models today are very, very different than the inputs that went into the model that California and CARB used in 2014. And so the challenge here is ultimately that New Mexico is at risk of adopting very outdated value for corn ethanol. And so I'll pull up my demonstrative exhibit once more, and I want to show you the next slide here. So this is just showing side by side this particular table, the indirect land use change values being proposed by NMAC on the left, and then the most recent values from C Club, which are shown on the right. Now, want to note a couple of things. C Club does not show uniformly lower indirect land use change values than CARB did back in 2014, especially because of that change in the carbon stock inputs between 2006 and 2019. What that means is certain feedstocks, canola is a great example up there, we now believe would have actually higher indirect land use change emissions. This is simply because not all biofuels feedstocks are the same in terms of how they interact with carbon on the land. So approximately half of the pathways shown up here are showing higher ILUC values under C Club, and about half, including corn ethanol, are showing lower values. And what's really important to call out is the corn ethanol value, because that is so much lower than what the New Mexico proposal is containing. And that really has to do with all of those changes that I have just detailed previously. Now, final note I want to make with this is, we have seen a lot of development since 2014 when it comes to indirect land use change values for corn ethanol. And my final figure for my direct testimony is really showing, and this is based on a meta-analysis that was done a few years ago, is showing between 2008, I shouldn't say a few years ago, this was last year, is showing the change between 2008 when that first seminal analysis was put out and 2024, which is the values that I just listed on the previous table. And what you will see is, notwithstanding many comments by NMAC witnesses saying that California's values in 2014, or what is showing up here as 2015, were middle of the road, they were very conservative, which is to say they were on the high end relative to what the literature was showing even back then. And I think that made sense because they were adopting the precautionary principle. They were concerned about the lack of data availability They understood they were making some pretty major assumptions. And so they ultimately adopted a relatively high value in response to that. But that doesn't mean such a high value is appropriate today. And especially in light of the changes that we have seen to modeling, the improvements, not just in the US, but also in the European Union, other parts of the world that model this, what we see for corn ethanol is that the values have ultimately changed quite a bit. And they have dropped substantially for across modeling frameworks since 2014. So in conclusion, I just want to note that New Mexico's proposed value of 19.8 grams of CO2 equivalent per megajoule, because it is so much higher than the value of 6.1 grams of CO2 equivalent that Growth Energy is proposing for use instead, based on the latest data from the C Club model. By adopting a higher value, New Mexico would essentially cause two potential problems with the Clean Transportation Fuel Standard program. The first is that it would be relying upon outdated data. And so that, because these are processes that take multiple years to update, the use of 2004 vintage ILUC values would ultimately understate the benefits being provided for corn ethanol in particular. And so that's another way of saying there would be that much more that would have to be done under the program to hit the targets simply because of the use of 11-year-old values. And so that's a shortcoming right there. And the other shortcoming is that by requiring additional inputs to the Clean Fuel or Transportation Fuel program, NMAD is potentially increasing the cost to consumers. And that's because you essentially increase the cost at the margin of complying with the program. Now, again, I don't want to say that a low price is good just on it of itself, right? But if the low price is not supported by the data, then you're essentially increasing the cost of compliance to consumers without any justification. So to wrap it up, just want to note, again, Growth Energy is proposing the use of 6.1 grams of CO2 equivalent per megajoule for corn ethanol's ILUC value, rather than 19.8 grams of CO2 equivalent per megajoule. Adopting 6.1 would bring New Mexico in line with not just the latest science on ILUC, but also in line with what the federal government did during the Biden administration and is in many cases continuing to do moving forward with the various tax credits that were created under the Inflation Reduction Act. That concludes my direct testimony. Thank you.
Thank you, Dr. Brown. Dr. Brown, did you file a rebuttal testimony in these proceedings?
I did, yes.
And do you have any changes to the written rebuttal testimony that you filed?
No.
And do you adopt that written testimony as your testimony today?
I do, yes.
And what is the purpose of your rebuttal testimony, Dr. Brown?
The purpose of my rebuttal testimony is to rebut testimony, both written and oral, that was made by NMED witnesses Dr. Colin Murphy, as detailed in NMED Exhibit 12, Ms. Claudia Borchard, as detailed in NMED Exhibit 63, Dr. Angela Rosso, as detailed in NMED Exhibit 67, Mr. Michael Ford, as detailed in NMED Exhibit 73, and Mr. John Kupal, as detailed in NMED Exhibit 80, and their corresponding oral direct examination, cross-examination, and redirect examination testimony given at the EIB hearings.
Dr. Brown, would you summarize for the board and the hearing officer your rebuttal testimony?
Yes. So we really have three things for this. First, I will be providing a summary of the way that NMED proposes to utilize United States and state government modeling in support of the revised proposed new rule 20.2.92 NMAC Clean Transportation Fuel Program. I will specifically focus on the lack of uniformity that results from NMED's current proposal. Next, I will detail how NMED's witnesses have incorrectly assessed the indirect land use change values, including for corn ethanol, shown in Table 9 of the revised proposed new rule, as representing the state of the science. I will explain why Table 9's corn ethanol IOUC value of 19.8 grams of CO2 equivalent per megajoule is too obsolete to represent the state of the science, and I'll discuss how NMED's incomplete review and reliance upon a single meta-analysis study directly resulted in this faulty assessment. Finally, I will show that a proper consideration of the state of the science through the incorporation of the ILUC modeling efforts that were conducted between 2017 and 2024 specifically, instead supports the use of the corn ethanol ILUC value of 6.1 grams of CO2 equivalent per megajoule that was presented in my direct testimony that was submitted on September 2nd, 2025. One thing that stood out to me in reviewing both the written testimony and the oral testimony of NMED's experts and the witnesses was the repeated references across the board to the use of US and state government modeling outputs that represent, and I quote, the state of the science. 4 specific such modeling efforts are referenced. The first is the Research and Development GREET model. The second is the OPG, that's OPGEE, which is short for Oil Production Greenhouse Gas Emissions Estimator, version 2.0C model. The third is the 45V, that's Victor, GREET model. And the fourth is the US Environmental Protection Agency's modeling of the social cost of carbon. In all 4 cases, the NMAD has chosen to use outputs from versions of those models that have been substantially updated in a very iterative process and improved compared to those versions that existed in 2014. I will pull up real quick. I've got a table with my demonstrative exhibit showing what this looks like. Sorry, let me go back here. Here we go. So what you'll see here are the 4 models in question. On the left, I'm showing the model version year used by NMED. On the right, I am showing the most recent model version year available. In all cases, NMED is opting to use, for these first 4 models that is opting to use fairly recent models. Not necessarily always the single most recent estimate, but certainly model estimates for versions of the model that were produced within the last couple of years. The one very notable exception to this particular rule of using the state of the science for modeling efforts is our indirect land use change, where, as I have noted, NMED is proposing to use values from a model. Too fast again?
Too fast.
All right. Where would you like me to start back? Okay, I'll just slow down. In the case of ILUC, New Mexico is proposing to use model outputs from 2014 instead of the most recent model year available, which is 2024. I think that's notable, right? The year 2014 is where those values were produced. And NMED's witnesses have not explained why the department has opted to utilize updated modeling in support of all major modeling efforts that it is adopting, with the exception of ILUC. And by doing so, this is very incongruous. NMED is ignoring modeling outputs from the multiple upgraded and improved versions. I count at least 3 or 4 since 2014 of the C Club model that are available to it, rather than using a 2014 output. Now, in the testimony that NMED provided, there was multiple references to a 2022 meta-analysis, or specifically a meta-analysis study. And I'm referring specifically to Mr. John Kupel's evidence that was provided. Got a closer look at this meta-analysis because this was really noted. It was noted in the evidence that this was the primary reason, right? And basically what Mr. Kupel, if I can restate what he said, was that this meta-analysis showed average value, or showed a number of different outputs for corn ethanol indirect land use change values that had been estimated by studies over the years. And the average value was very close to what NMAD is proposing to use. And so this was the justification and support. The 2022 meta-analysis is actually a presentation that is based on a 2020 study So 2-year difference there. And the 2020 study is based on studies that were conducted between 2008 and 2017. And so if I may show my next demonstrative exhibit here. This is a histogram showing the publication years for all of the studies that were listed in NMAD Exhibit 105. What you'll note is virtually all of them are from 2015 or earlier, and more than half of them are actually from 2012 or earlier. So I think it's worth stating that it's not surprising that Exhibit 105 ultimately aligns with NMAD's proposed ILUC value for corn ethanol, and that's simply because NMAD is proposing to use a 2014 modeling output, and it should not surprise us that a 2014 modeling output is closely aligned with other studies that were published about the same time. And so this is I would call this a shortcoming in the justification, because again, a lot has happened, as I noted in my direct testimony, between 2014 and today. And if we were to look at this more expansively, and I'll show my next figure here, if it pops up. Here we go. What I have done to put this figure together is I have taken the references in Exhibit 105, and those are the lines on the white backdrop. Those are all the studies that I just showed between 2008 and 2017. These are the calculated corn ethanol indirect land use change values, and I've updated them using values that have been published between 2017 and 2024. And the dashed blue line is ultimately just a linear trend line. And what we see is that the value that CARB calculated in 2015 is quite high compared to the values that have been published since 2017. Now, I also want to note something with this, and so I've called out in that box CARD plus FAPRI model estimates. This is the modeling suite, so I'm trying to be careful to show not just C Club here. I want to show multiple modeling frameworks, how they have changed over time. CARD plus FAPRI, this is the modeling suite that was used in that very first ILUC study back in 2008 that I mentioned in my direct testimony. They revised that using better data in 2011. This was the same model framework, just updated. This was in many cases the same modelers that ran this model. They got a value just 3 years later that had fallen by about 45%. In 2020, they ran the latest version of the CARD plus FAPRI modeling suite a third time. And they got an indirect land use change value for corn ethanol of 13.1 grams of CO2 equivalent per megajoule. So it is not just the C Club modeling framework that has shown steady reductions to corn ethanol indirect land use change values over time. I would go so far as to state those modeling frameworks that have been in existence for the last 11 plus years generally all show declining values for corn ethanol. The only modeling frameworks that are not showing declining values are those such as the AEZ-EF modeling outputs that California used in 2014 that have not been regularly updated since then. And so NMAD proposing to use a modeling output from 2014 is effectively ignoring everything that has happened since 2014. And so if New Mexico is going to adopt and really focus on employing the state of the science, I just want to note New Mexico is proposing to do that by relying upon studies that were largely calculated prior to 2015 and certainly calculated around the 2012 and 2013 time span. So in conclusion, right, we have an internal inconsistency here in 2 ways. The first is NMAD is using recent modeling efforts for just about every major part of the Clean Transportation Fuel Program, with the exception of indirect land use change. And the second key inconsistency here is that New Mexico is, and NMED specifically, is saying that it is adopting the state of the science on corn ethanol indirect land use change, even though, as I just showed in that demonstrative exhibit, the state of the science on corn ethanol indirect land use change has changed drastically over the last 11 years. And so I would propose that New Mexico could adopt the state of the science across the board by employing and adopting in Table 9 a indirect land use change value for corn ethanol of 6.1 grams of CO2 equivalent per megajoule instead of 19.8 grams of CO2 equivalent per megajoule. That concludes my rebuttal testimony. Thank you.
Thank you, Dr. Brown. Madam Hearing Officer, we pass the witness.
Thank you very much, Mr. Nasco and Dr. Brown. Ms. Zona, I refreshed my memory on the order of cross, and you always went last. Is that still your pleasure?
Yes, that is still our preference.
All right, thank you. Mr. Noyes, do you have questions of Dr. Brown for Next or Infinium or SAFCO?
Madam Hearing Officer, no questions. Thank you.
Thank you. Mr. Duff, do you have questions for National Sorghum? May not be with us. Mr. Smith, do you have questions for Rio Valley Biofuels? And just to confirm, Pam, they can all unmute themselves, correct? Okay, thank you. Mr. DeSalen, do you have questions for CCAE?
No questions, Madam Hearing Officer?
All right, thank you very much. He said no questions. Mr. Lobdell, do you have questions for Food and Water Watch?
Madam Hearing Officer, no questions. Thank you.
Thank you. Mr. Sorayas or Mr. Wade, do you have questions for Renewable Natural Gas Coalition?
Madam Hearing Officer, we have no questions. Thank you.
Thank you. Ms. Vercruz, do you have questions for the Low Carbon Fuels Coalition? Right. Ms. Tremblay, do you have questions for Southwest Airlines? Mr. Maxwell, do you have questions of Dr. Brown?
No questions, Your Honor. Thanks.
Thank you. Mr. Weatherby, do you have questions of Dr. Brown?
No questions, Madam Hearing Officer. Thank you.
Thank you. Mr. Boutier or Mr. Harris, do you have questions for Sinclair?
No questions, Madam
Thank you. He said no questions. Mr. Tucker, do you have questions for Oxy? There you are. All right, thank you. Ms. Olson, do you have questions for AFPM?
No questions.
Okay. Mr. Trujillo or yes, Mr. Molenberg.
Thank you, Madam Hearing Officer. I have a couple of questions for Dr. Brown on behalf of the New Mexico Oil and Gas Association and the American Petroleum Institute. Dr. Brown, thank you for your testimony today. Just have a couple of questions here. The first being relatively simple. So you have presented calculations of carbon intensity values for corn ethanol to the board, correct?
That's correct, yes.
And your calculations were produced using the what's known as the R&D GREET model produced by Argonne National Laboratories, correct?
Just to clarify, I did not calculate those values.
Okay.
Argonne National Laboratory calculated those values.
Okay. Could you elaborate on that, where those values can be found, or is it in some publication of Argonne National Laboratory?
So there's a combination, if we're specifically referring to the C Club values that have been published over the years. In many cases, they are in the peer-reviewed literature. And so these have been published by scientists at Argonne National Laboratory, but rather than appearing in, say, a technical report, which many of the GREET outputs sometimes have been, they're published in various peer-reviewed scientific journals. And that is where most of those values are found. In some cases, there are technical reports that will contain values, but most are in the literature.
So the value that you've provided is from the literature?
Well, so I've shown multiple values.
Okay.
In some cases, and the references are included in both my direct and rebuttal testimony for the individual values. It will note where that's from the literature specifically.
Okay, thank you very much. Earlier this morning, you testified regarding a couple of conclusions that you have made relating to the Environment Department's approach to the ILUC issue. And one of those is that the Environment Department's approach would increase price impacts on consumers. Do you recall that?
Other things being equal, yes, a higher CI score could be expected to increase price impacts for consumers.
Okay. Could you elaborate on why, in your view, that would be the case, that the higher CI value produced using the Environment Department's model would result in greater price impacts to consumers compared to a lower value, as you have suggested?
Yes. So other things being equal, anytime you increase the carbon intensity score of something that's going to be participating, you're effectively saying that you are going to require more of that in order to achieve a specific reduction to greenhouse gas emissions. And so the gallons that would be required, or alternatively, other things being equal, you're basically increasing the marginal carbon abatement cost for all of the technologies, all the fuel pathways participating, and you're going to be increasing the credit price that would be required to achieve a specific level of decarbonization.
Okay. Dr. Brown, thank you very much. That concludes my questions.
Thank you.
Thank you, Mr. Mullenberg. Ms. Sona, do you have questions of Dr. Brown?
Good morning, Dr. Brown. Madam Hearing Officer, before I begin my questions, I just wanted to address a concern, and so providing an oral motion that Dr. Brown's oral testimony should not be considered as evidence in this matter because there is not an opportunity to fully examine on cross-examination for the truth of the matters he asserted. His oral testimony goes beyond the scope of what he provided in writing for both his direct testimony and his rebuttal testimony. And so given that problem, I don't think it's fair to consider it as evidence in this matter. Additionally, as a procedural matter, his demonstrative exhibit was not shared with the parties for his direct testimony in advance of providing it at this hearing.
So, Ms. Sona, I was seeing those same tables in the direct testimony. Like that was one of the slides. I think that was one of the slides.
My concern about the demonstrative exhibit, Madam Hearing Officer, is just for the record. I understand they're in the record in his testimony, but he did not disclose he would be demonstrating them before the board.
Oh, okay. Well, all right. So that objection, I'll overrule. I mean, we had it with us either electronically or on paper. As to your first objection, though, is there something in particular you can identify that he testified about that was not in his direct or rebuttal?
Yes, Madam Hearing Officer. I don't want to be held to have to point out every example of what could have been beyond his written, but two examples that were identified is his discussion regarding the impacts of trade with China, as well as his commentary on the summit happening in Brazil.
Okay. I think we're going to just slide past that as well. I understand they were extraneous, but we seem to be awash in that news. But thank you. Was there anything else? Oh, you were going to question him.
Yes.
Yes. Okay, go ahead.
Let me grab my phone for time. Good morning, Dr. Brown. My name is Kelsey Sona. I'm counsel for the New Mexico Environment Department, the petitioner for this rulemaking. To get us started, I wanted to ask you, your testimony recommends using for ILOC the most recent version, I'm going to read a long phrase here, of the Argonne National Laboratories Research and Development GREET Models Global Trade Analysis Project and Carbon Calculator for Land Use and Land Management Change from Biofuels Production Modeling Framework, or the GTAP Bio plus C Club, correct?
Yes.
Okay. If I just say C Club today, are you going to know what I'm talking about?
I will, yes.
Okay, great. So Dr. Brown, you have a Juris Doctor, but you are not licensed to practice law in New Mexico, correct?
Correct.
And none of your testimony provided in writing or orally today is intended to be that of an attorney, correct?
Correct.
You describe yourself as an energy economist and a policy scholar. Would that be fair?
Official title is energy resource economist, but it's a bit of a mouthful.
Okay. And your primary appointment is in an academic setting, not a regulatory setting, correct?
Correct.
And your professional career, at least as shared in your resume, has been spent entirely in academia. Is that correct?
Correct.
And you have not personally developed or calibrated the C Club model, correct?
Correct. I have worked with GTAP, but not with C Club.
Several of your recent projects have been funded by industry organizations, including the National Biodiesel Board and EcoStrat. Is that correct?
If you're referring to academic research grants, yes.
Yes, thank you. The National Biodiesel Board, is it fair to say that they represent producers of low carbon fuels seeking favorable regulatory treatment?
I would clarify that as they are focused on distillate fuels. They do not represent ethanol fuel.
Okay. Has any of your research ever been funded by Argonne, Department of Energy, or CARB?
Little tricky to answer the Department of Energy one because I am part of a project team where we received a grant. This was announced in December of 2024, and we're not entirely sure what's going on with it right now. So, yeah, but I mean, this was an official award announcement, so I just want to clarify that, but we have not completed the project, I'll put it that way.
Thank you very much. So you're here testifying today on behalf of Growth Energy. And Growth Energy is a U.S. trade association that represents the interests of producers, growers, and companies involved with producing corn ethanol, correct?
Corn ethanol, correct.
And your testimony was prepared on behalf of Growth Energy, correct?
Yes.
The only regulatory change that you recommend is to lower the ILUC values for plant-based fuels like corn ethanol, correct?
Specifically corn ethanol.
So you're not recommending any other changes except to the ILUC for corn ethanol?
The 6.1 grams of CO2 equivalent per megajoule. That's the one I'm recommending.
So is the answer a yes?
The answer is a yes.
Okay, thank you. And at a high level, lowering the ILUC values makes corn ethanol a lower certified carbon intensity, right?
Other things being equal, yes.
Which means that corn ethanol producers would generate more credits under the program, right?
Correct.
So Growth Energy's recommendation, if adopted, would financially benefit their members, correct?
We could assume so, yes.
And given that, it's fair to say that your testimony advances a policy outcome that's aligned with producers' interests, correct?
I would say in this case, the producers' interests are aligned with the state of the science on indirect land use change for corn ethanol, yes.
In a clean fuel standard like the LCFS or this program that as proposed by the department, would a fuel with a lower CI score receive more or less incentive per gallon than one with a higher score?
Other things being equal, we would expect more.
Thank you. And in general, would a fuel with a lower ILUC impact tend to have a lower CI score in a clean fuel standard than a fuel with a higher ILUC impact?
If we're just focusing on a difference in ILUC, then yes.
You can assume for most of my questions, that's what I'm going to assume. Are you aware, Dr. Brown, of whether or not the members of Growth Energy are also members of other trade associations that are parties to this proceeding?
I have no knowledge of that.
Do you know who does have knowledge of that?
It's a very open-ended question. I would assume staff at Growth Energy would have that information.
Are you aware of whether any of Growth Energy's members operate production facilities in New Mexico?
I am not aware of personal knowledge, no.
Okay. Do you have any reason to believe that they do operate facilities here in New Mexico?
I'll be honest, I'm from the Midwest. I don't know a whole lot about ethanol facilities in the Southwest US.
Well, welcome to New Mexico as a fellow Midwesterner.
Thank you.
So given your answer just now, I'm guessing that you're also not aware of whether there's any proposals from Growth Energy's members to invest or create jobs in New Mexico?
No, as an independent consultant, I got to keep my eye on the ball, and there's one topic I'm talking about, so I don't have personal knowledge of these other areas not related to my testimony.
Okay, thank you. Are you aware that California developed its ILUC model framework in a multi-year process with a scientific expert working panel composed of world-class experts from industry, academia, nonprofits, and other interested parties?
Yes.
And CARB recently updated their low carbon fuel rules in 2024, correct?
Yes.
And as part of that rule update, CARB did not adopt the ILUC approach that you're recommending today, correct?
Correct. Just to clarify, CARB has not changed the values from 2014. So it wasn't so much they updated values, it's they're staying with the 2014 outputs.
And along with their decision, they also agreed to convene a working group to look at ILUC values, correct?
Yes.
So those facts taken together, you're recommending to this board that they do something that CARB was not willing to do 1 year ago, correct?
Well, in the sense that I am recommending that new values be adopted that update what has been done since then, whereas CARB has decided not to change the values from 214. And yes, that is correct.
It's true, right, that no other state uses the C Club model for all plant-based fuels, correct?
Oregon uses it for corn ethanol because, as I understand it, that was the only C Club value that was available at the time that Oregon was developing its program. But with that clarification, yes, you are correct.
And Oregon, since that adoption, has not revised or updated their value for corn ethanol ILUC, correct?
Correct.
Are you aware that Oregon did not conduct a multidisciplinary expert review like California's when it selected that C Club value?
Well, that becomes something of a subjective statement. It was a very different process in many ways, yes.
Very different, but it did not have a robust expert years-long committee review preceding the decision.
Well, I think it's important that we distinguish what the situation was in 2014 compared to what it was several years later when Oregon was running through its process. In 2014, there was no precedent to go off of. So when California put together that process, and I agree, California put a very intensive process together, it was because that had never been done before. Oregon had the advantage, as coming in next, as being able to build off of what had already been done. So from Oregon's perspective, I would say there was no need for them to completely reinvent the wheel by running through an entire process already. What they viewed it as needing to do was to update what had changed since California had run through its process several years before that.
Let me ask this another way, maybe. Oregon did not have a expert committee review the C Club ILUC values prior to adopting them, correct?
Again, I feel the need to clarify here. So GTAP Bio plus AEZ-EF was novel. And so it had not been reviewed before. C Club has gone through many, many years of intensive critiques and revisions and updates. And so simply because they did not do the start of the process the same way California did, I would not say that they just kind of did this flying by the seat of their pants.
Dr. Brown, are you aware that there are no public or published technical bases explaining why Oregon chose a lower corn ethanol ILUC value?
In terms of one choice over another, I couldn't answer that to my personal knowledge. What I do know to my personal knowledge is that the values that fed into Oregon's system were based off of public literature.
Are you aware, Dr. Brown, of
Council,
whether...
can you hear me?
Pam?
I have been out of the system for about 5 minutes.
Oh,
Oh dear.
no, we weren't able to hear you.
That's because my system had frozen completely.
Oh, all righty.
The last thing I have was for asking him to assume I have, if we are focusing on the difference in ILUC, then yes, question you can assume for most of my question, that's what I'm going to assume. And that's probably 5 minutes ago.
Is that true, Ms. Sona?
Madam Hearing Officer, I do recall that point in our exchange. I believe that this is being recorded still, Ms. Jones?
Yeah.
I'm comfortable and have no objection for the court reporter gathering the cross-examination from the recording for our transcript purposes.
So, David, we only have about 4 or 5 minutes left in Ms. Sona's questioning. I'm wondering if you could get the last 4 or 5 minutes from the recording and we can proceed and then take a break.
Yes, ma'am.
Thank you very much.
For clarification, Madam Hearing Officer, I may go slightly over 15 minutes because it was my understanding for direct, we would have had 30 minutes to cross and redirect 15 to cross. I'm going to go nowhere near 45 minutes, though, but I may go a few minutes over.
Thank you.
All right, Dr. Brown. If New Mexico were to follow Growth Energy's proposal to have the different lower corn ethanol ILUC value, it would depart from the majority of other state programs and risk an opportunity for regulated parties to game the system, correct?
Just to note, when you say majority, there's not that many. So at that point, you would be 2 and 2.
Are you aware, Dr. Brown, of the directive the legislature provided to the department and this board to, in section 74-1-18C6 of the authorizing statute for clean fuels to, quote, consider similar programs in other jurisdictions?
Yes.
As part of your testimony, you shared some criticisms of the meta-analysis cited by ERG, generally as being outdated. Do you recall that testimony?
I do, yes.
Are you aware that there are other more recent studies that lend further evidence that C Club is underestimated?
I assume you're referring to exhibit NMAD exhibit 139-B.
I don't have the exhibit number in front of me, but I'm referring to studies by Lark in 2022 and the EPA model comparison exercise in 2023.
Yes, I'm aware of both.
Dr. Brown, you did not conduct a benefit cost analysis showing the economic effects of substituting ILUC values for C Club into the department's regulatory model, correct?
Correct.
And so you cannot say with modeling certainty how your proposed change would affect program credit prices, compliance costs, or consumer fuel costs, correct?
I am only able to speak to basic economic principles with other things being equal, but to your level of specificity, correct.
Thank you. At some point in the Clean Transportation Fuel Program for New Mexico, corn ethanol fuel becomes a deficit generator, correct?
Under the way it's been modeled by NMAD, correct.
And so Growth Energy's proposal would extend the point at which corn ethanol becomes a deficit generator, meaning, in other words, it has more time as a credit generator, correct?
Other things being equal, yes.
And similarly, Growth Energy's proposal means corn ethanol fuel stands to generate less deficits in the later years of the program, correct?
Yes.
You testified about seeking alignment with federal programs. Would those be the U.S. Department of Treasury and the U.S. Department of Energy?
Well, specifically, we would be looking at the Inflation Reduction Act provisions. So similar to the 45V model, they should be such as the 45ZEF model. So in support of those programs, yes.
And those are not credit and deficit clean fuel market programs, correct?
Those are tax credits.
Madam Hearing Officer, that concludes my cross-examination. Thank you, Dr. Brown.
Thank you.
Thank you very much. Mr. Nesco, will you have a redirect? We do need a break soon.
Thank you, Madam Hearing Officer. Very briefly on redirect, if I may. Dr. Brown, a couple of things. First of all, a very basic question. When Growth Energy asked you to analyze and propose ILUC values, they do so based on they tell you they were doing so based on the financial interests of their members or the need to ensure that New Mexico's program adopted appropriate and accurate values?
The second option.
All right. I think Ms. Sona was asking you about the vetting and professionalism of CARB when it analyzed its did its studies in 2015, 2014. Are you criticizing the professionalism used by the state of California during that period?
No. What California did in 2014 represented the state of the science in 2014. Yes.
Just to clarify then, your testimony concerning the CARB values has nothing to do with the analysis done at the time, but rather with the failure to update that analysis with iterations and current data. Is that an accurate statement?
Correct. It's reflecting everything that has changed and improved since that was done in 2014.
Now, Ms. Sona also referenced a LARC study and an EPA study that the NMAC witnesses have testified about. Did you recall? Do you recall that?
Yes, I do.
And what's your perception of those particular studies? And could you explain that to the board and the hearing officer?
Both studies, and we're referring here to NMAD exhibits 139B and 139D, they essentially make similar statements regarding their outputs. So the LARC et al., or what some refer to as the LARC et al. Study, exhibit 139-B, if you dig into the supporting information, which is in this type of journal, this is where the modeling inputs and assumptions are contained. It's not contained in the exhibit, but it is part of the study that is published with the study. On page 33, the authors write that the primary difference between the LARC et al. Result and C Club's results has to do with differences in assumed emissions factors. And so everything I was referring to in my testimony still stands. These two studies used different, the primary difference was the difference in assumed emissions factors. And if you take exhibit 139-D, which is the Teherapur study, that actually goes a step further. And it actually points out that the primary difference, the main difference, is the difference in emissions factors. And I mentioned figure 3 of that particular exhibit, which is showing the differences in emissions factors between the AEZ-EF model and the C Club model.
Thank you, Dr. Brown. No further questions, Madam Hearing Officer.
All right, thank you very much. It's 10:35. Let's come back at 10 of 11 and we'll have questions from the board members. When we broke, all of the questioning had been done by the parties. Dr. Brown, we turn now to the board. Member Ely, would you like to kick us off?
Yeah, just a couple questions. Is this on? Yeah. Dr. Brown, good to see you this morning. So I'm just trying to understand the practical implications between the 19.8 and the 6.1. Does the 6.1 is about a third of the 19.8. So does that mean the value that Growth Energy is proposing estimates that the greenhouse gas emissions related to the land use changes related to ethanol would produce about a third of the emissions as to what NMED is proposing? Is that
Correct. And I mean, so yeah, just to point out, it's not to say that there is no indirect land use change emissions, but it is reduced. And what that really reflects is, for the reasons I detailed, the expected emissions or the calculated estimated emissions based on the state of the science in 2014, we now believe overstated what's actually happening. And so when you see a reduced number like that, it's because the models have been refined, the databases have been improved, and that number has come down.
Yeah, thank you for your testimony. I think I understand that part, that you're proposing that this state of the science is different than what NMED is proposing. I was just trying to understand what was practically happening. And then, so there was in the cross-examination, there was discussion about if New Mexico were to move forward with this value, the same as California, it would be a 2 for 2 on the states. Oregon has a different value. And are you saying Washington State has a different value too for corn ethanol?
Yeah, so to clarify, Washington State has adopted the California value. Oregon has adopted the C Club value from a couple of years ago. So Oregon's value is 7.6. So much closer to what I am proposing than California. So when I say 2 for 2, it would really be 2 that are using the 2014 AEZ-EF outputs and 2 that are using more recent C Club outputs.
That's all. Thank you.
Thank you. Chair Sweeney, would you like to go next?
Thank you, Madam Hearing Officer. I don't have any further questions.
All right, thank you. Member Garcia, on the platform, do you have questions of Dr. Brown? You may have stepped away. Let's see, Member Honker, do you have questions of Dr. Brown? I'm not sure if we have Member Bitzer on the platform. No. Okay. All right. Well, I think you're off the hook, Dr. Brown. Is there any reason not to excuse Dr. Brown? No? I thank you very much for your testimony.
Thank you, Madam Hearing Officer.
We're going to Mr. Murphy. Is that what I understand?
Yes, that's my understanding.
Good morning, Dr. Murphy. Are you able to hear me?
Yes, just fine.
Wonderful. Madam Hearing Officer, may I proceed with Dr. Murphy?
Yes, since I already swore him in a couple weeks ago, yes? All right, Dr. Murphy, you're still under oath.
Yes.
Dr. Murphy, for clarification and a clean record, can you please state and spell your name for us again?
My name is Colin William Murphy, COLIN WILLIAM MURPHY.
And Dr. Murphy, did you previously testify in this proceeding on September 23rd and 24th in 2025?
I did.
I'd like the record to reflect that Dr. Murphy's qualifications to testify were previously established on the record and in Exhibits 12 to 33 with his direct testimony, resume, and supporting exhibits, which were all admitted. Dr. Murphy, is NMED Exhibit 115 a written narrative of your rebuttal testimony?
Yes.
And do you adopt that testimony under oath today?
Yes.
Have you prepared a summary of your written testimony?
I have.
Thank you. Please go ahead and read your summary. And as a reminder, go slowly.
Thank you. Thank you, Madam Hearing Officer. My name is Colin William Murphy. I am the co-director of the Energy Futures Research Program at the University of California, Davis Institute of Transportation Studies, where I also co-direct the Low Carbon Fuel Policy Research Initiative and direct the Biofuel Land Use Change Program.
A little
I lead
slower.
ITS.
A little
Slower?
slower.
Very well. I lead ITS Davis work on alternative fuel technology and policy, especially programs like the Low Carbon Fuel Standard in California, which I will often abbreviate as the California LCFS, which has been a model for similar programs in Oregon, Washington, Canada, and Brazil. I have a PhD in transportation technology and policy from ITS Davis, and for the last decade, the largest share of my professional time has been dedicated to researching, modeling, and speaking about programs like these. I've published around 20 peer-reviewed journal articles or technical reports on topics related to clean fuel standards, and I've also submitted literally hundreds of pages of technical comments on clean fuel standard development and implementation during rulemaking proceedings in multiple jurisdictions. My role in this hearing has been to bring the perspective I've gained over these years, as well as my scientific understanding, to help explain some of the core concepts in this space and discuss how similar programs.
Dr. Murphy, you really need to keep it slow.
Slower?
Bring it down,
Okay.
keep it slow.
Sure. All right.
My role in this hearing
has been to bring the perspective I've gained over these years of work, as well as my scientific understanding, to help explain some of the core concepts in this space, as well as discuss how similar programs in other jurisdictions have performed. In my rebuttal testimony, I will provide some additional detail on 4 topics that have captured significant attention during the first phase of this hearing. First is energy economy ratios and technology neutrality. Second is indirect land use change and the replacement of feedstock consumed by biofuels. Third is the impact of clean fuel standards incentives on livestock production. And fourth is the risk of refinery closure. As I discussed in my initial testimony, these are complex topics that are not easy to reduce down to a discussion that can be addressed in a few minutes or pages, and I welcome the opportunity to follow up and get deeper into these issues. In the interests of full transparency, I want to disclose that my colleagues and I at ITS Davis are under contract to the New Mexico Department of the Environment to provide technical assistance related to the design and implementation of CTFP. I have no other competing financial interests in this matter, and my ITS Davis colleagues and I are bound by professional and ethical obligations to provide transparent, evidence-based, unbiased guidance to support the public interest. No contract or financial relationship supersedes these obligations. And at the same time, nothing I say or suggest should be taken as an official statement from the University of California or any state entity. All material is solely my responsibility. The first topic I want to speak about is energy economy ratios, or EERs, and technology neutrality. In the first phase of this hearing, some witnesses suggested that the presence of EERs violates the principle of technology neutrality that helps guide CTFP development and implementation. Other witnesses stated that the presence of EERs for some powertrains, but not for gasoline and diesel, internal combustion engines, which I will abbreviate as ICE or say as ICE, violates the principle of technology neutrality. This is simply incorrect, and I think it is based on a misunderstanding about what precisely the EER is. The California LCFS defines EER in this way. A full citation to the section of code and deeper examination of some of the terminology is in my written testimony. Quote, the energy economy ratio, EER, means the dimensionless value that represents the efficiency of a fuel as used in a powertrain as compared to a reference fuel used in the same powertrain. Other clean fuel standards adopt very similar definitions. Obviously, when the same powertrain cannot consume a fuel, like how an internal combustion engine cannot consume electricity, then you use the closest comparable example. The critical elements here are the terms dimensionless value and as compared to a reference fuel. An EER is a ratio of an alternative fuel vehicle efficiency to a conventional vehicle's efficiency. That is what as compared to a reference fuel means in this context. The term dimensionless value means that there are no units associated with the EER. So whereas mass can be measured in units of pounds or kilograms, sound intensity in decibels, and a speed in units of distance per unit of time, like miles per hour, the EER is dimensionless. It has no associated units. The fact that it is dimensionless reflects the mathematical reality that when you divide any quantity of something by some other quantity of the same thing, the units cancel each other out, leaving you with a dimensionless number. To obtain an EER, you divide the fuel economy of one type of powertrain by the fuel economy of the conventional powertrain. The units of fuel economy cancel each other out because they are both ultimately a distance divided by a unit of energy. And when you divide a number with one type of unit by a number with the same type of unit, the units cancel each other out and you are left with a number that has no units, which is to say, a dimensionless value. This should illustrate how the definition I provided above not only describes how you derive EER, but describing it as dimensionless creates an immediate double check to make sure that you did the math right. This is the mathematical understanding shared by all similar regulatory programs and experts in this space. And here's why I just subjected you to this unsolicited math lesson. An EER is derived by dividing the efficiency of one powertrain by the efficiency of the reference powertrain. This means that the efficiency of the reference powertrain, which is gasoline or diesel, is mathematically part of every EER. Once this relationship is understood, it becomes clear why no EERs are listed for conventional ICE powertrains. The EER of a conventional ICE powertrain is the fuel economy of that powertrain divided by itself. It is precisely one under all circumstances. It is not that the rule omits consideration of the efficiency of these powertrains. Rather, the efficiency of ICE powertrains is embedded into every other EER in the program. The efficiency of gasoline engines is included in every EER that uses gasoline as the reference powertrain, and the same applies to diesel, jet fuel, or any other technology for which a category of reference EERs is created. It essentially goes without saying that the EER of an internal combustion engine is equal to 1. And because EERs are multiplied into the crediting equations used by programs like CTFP, an EER of 1 has no impact on crediting. Now, one could reasonably object to the value of an established EER for a given pathway on the basis that it may overestimate or underestimate the fuel economy of either the alternative or the reference fuel. But this does not seem to be the claim made by the parties in this case. Rather, their arguments seem to be that the lack of an EER for conventional pathways indicates that EERs violate technology neutrality at a conceptual level. And that is not supported by any of the research on this topic, nor by the definitions and interpretations of the issue made under similar clean fuel standard programs in other jurisdictions. I recall hearing testimony asserting that the efficiency of hybrid vehicles is not accounted for by the EER. Hybrid vehicles can use electric motors and batteries to improve fuel efficiency, though it should be noted that hybrids can also be configured to increase power or acceleration without an efficiency benefit. Even with this efficiency benefit, the primary energy supplying this hybrid vehicle is provided solely by the liquid fuel. And so the fuel economy of a hybrid is measured the same way as any other gasoline or diesel ICE vehicle. Hybrids were introduced into the US market in 1997 and were widely available by the mid-2000s. These effects were well understood when CARB established the EERs used by the LCFS.
Slow down again.
Sure, at the time of first implementation. It may be that these estimates need to be updated, but it is inaccurate to assert that that hybrids are excluded from consideration in the CTFP, or that the appropriate approach is to eliminate EERs completely. Ultimately, EERs are a necessary and scientifically based step to account for the differing fuel efficiency of diverse powertrains. Some of the powertrains are more efficient at converting stored energy into motion than others. About 25 to 35% of the energy contained in gasoline or diesel or other liquid fuels is converted into vehicle motion in a conventional ICE powertrain, whereas over 80% of the energy contained in a charged EV battery is converted to motion. Given that the purpose of transportation fuel is to move vehicles, accounting for this difference aligns with well-established scientific principles. Omitting EERs from the CTFP would require willfully ignoring testable, empirically demonstrated scientific reality, and technology neutrality does not mean technology blindness. The next topic I wanted to address is indirect land use change and backfilling feedstock consumed by biofuels. As I mentioned in my initial testimony, indirect land use change, or ILUC, may be the most complex part of an extremely complex subject. It is therefore unsurprising that several widely differing opinions on this topic have been represented in testimony to date. ILUC is a complex issue because assessing ILUC effects cannot be directly assessed, and instead can only be estimated by modeling. I told you in my initial testimony that even if you had all the technology from Star Trek, you could still not build an ILUC sensor. Estimating present or future ILUC impacts requires models. And models, especially ones seeking to predict future behavior, will always be uncertain. As I mentioned in my direct testimony, you cannot model the future, or in some cases even the present, without making assumptions that have no objectively right or wrong approach. Where you draw system boundaries, how you allocate impacts in multi-product systems, whether you treat the relationship between two variables as correlative or causal, how you predict uncertain future behavior, all of these elements are required as part of ILUC modeling, and all of them require assumptions or methodological choices that are to some extent subjective. On top of that, predicting future ILUC impacts requires modeling the future not once, but twice, because these models compare a future with biofuels to a future without them. So the impact of assumptions or methodological choices can be multiplied. All of this is meant to reinforce what I said in my initial testimony, that any single point estimate of ILUC impact developed by any given model is going to be uncertain, not only because of the technical complexity of the subject and our limited data, but also because of the unavoidable dependence on models on subjective decisions. This is also why more recent models are not necessarily an improvement on older ones, even if they can demonstrate improvements in data quality or other elements that can be subjectively determined. It is entirely possible that the benefits from better data or newer methods could be outweighed by changes to the subjective assumptions underpinning the model. So while there have been advances in scientific understanding or data quality related to elements of many ILUC models, there has been comparatively little investment in research or developing multi-party agreement around subjective assumptions to improve or standardize models optimized for regulatory applications, like developing the ILUC adjustment factors for the CTFP. Even efforts like the ICAO Technical Working Group developing protocols for assessing ILUC from biofuels used in aviation has focused on defining a set of acceptable existing models and guidelines on which to prioritize when they disagree, rather than developing a single approach. NMED elected to use the ILUC adjustment factors first developed by CARB and adopted into the California LCFS in 2016. These were developed as part of a long, transparent analytical process guided by a panel of third-party experts and informed by public comment. I provided a link to the final report in my written testimony, and more detail can be found in the LCFS rulemaking archive. while the ILUC factors CARB adopted in 2016 are quite likely outdated, the lack of policy-focused research into this issue means that no comprehensively superior alternative has been developed to date, and none of the results proposed as alternative ILUC adjustment factors have gone through an equivalently comprehensive and transparent vetting process. NMED's choice to use the CARB ILUC adjustment factors is eminently defensible in this context. This reduces the administrative burden on both NMED and regulated parties and harmonizes CTFP's approach with those in California and Washington. Various stakeholders have suggested alternative ILUC adjustment values, some with higher scores than the current proposal, some with lower. None of these appear to have a scientific basis that is categorically stronger than that which underpins the ILUC adjustment factors developed by CARB a decade ago.
Doctor, none of these appear to have a
scientific basis that is categorically stronger than that which underpins the ILUC adjustment factors developed by CARB a decade ago. It is especially hard to justify ILUC adjustment factors lower than NMED's current proposal. Quantifying the ILUC impact of a given fuel or feedstock is complex and highly uncertain. However, the diversity of models and modeling approaches out there means we have a pretty good understanding of the range in which the notionally true impact could fall. The ILUC adjustment factors adopted by CARB in 2016 are generally at the low end of the range of outcomes predicted across studies. I cited two sources in my written rebuttal testimony, the 2023 EPA intermodal comparison, which I also cited in my original testimony, and a 2017 literature review by Woltier et al. Related to the European Union Fuel Quality Directive to illustrate this point. These are not the only broad reviews of ILUC models, but they represent findings in this space. Both the EPA and European reviews project a very wide range of ILUC impacts, especially for fats and oils used in diesel substitutes. The proposed CTFP ILUC adjustment factors are at the low end of the range of possible outcomes. This suggests, though it clearly does not guarantee, that the quote-unquote true value is likely to be higher than the proposed value. Some stakeholders have proposed setting the ILUC value on any crop-based lipids, such as vegetable oil, equal to that of palm oil, on the premise that in the global marketplace, palm oil is the cheapest and usually the most readily available option at commercial scale.
Dr. Murphy? This is your counsel, Ms. Sona. We are approaching time, and I was wondering if you could please wrap up for us with a few of just the high-level points from your two remaining topics.
Sure. So on the issue of substituting palm oil, it's essentially oversimplifying a very complex system, and there are multiple reasons to believe the actual substitution would not reflect a 100% equivalence with palm oil. On the issue of CTFP impacts on livestock herd size from renewable natural gas, I would say that the evidence, and while there has been a significant amount of research onto this issue in agricultural economic literature, you can't really identify a significant deviation from broader industry-wide trends that apply everywhere and are unrelated to programs like the CTFP. And finally, on the issue of refinery closures and economic decisions, I sit on the stakeholder work group convened by the California Energy Commission to address this issue in California. And I can say that as a result of the conversations I've had with this work group, which includes stakeholders from industry, the LCFS has not been identified as a primary driver of refinery closure in California. It is related to other issues. And so the concerns that it might lead to refinery closure in New Mexico do not align with the evidence or our understanding of the issue.
Thank you very much, Dr. Murphy and Ms. Sona.
Thank you, Madam Hearing Officer. Before we turn to cross-examination, I'd like to move for admission of NMED Exhibit 115, which is Dr. Murphy's written rebuttal testimony, and the supporting exhibits, NMED Exhibits 116 through 118.
Thank you. I'll pause for a moment in the event there are objections. Okay, they're admitted. Thank you. Let's see, shall we start with Mr. Mullenberg?
Thank you, Madam Hearing Officer. Good morning, Dr. Murphy. Good to see you again.
Morning.
I have just a few questions for you. One related to the EER topic, and a few questions related to the ILUC issue. And I think by now we all know what we're all referring to about ILUC, if I use that term. Sounds like you're in agreement.
I think so, yes.
So, Dr. Murphy, with regard to the topic of the energy economy ratio, or EER, this morning you discussed your analysis as it relates to hybrid vehicles. Do you recall that?
Yes.
Does your analysis regarding hybrid vehicles take into account plug-in hybrids that derive energy from both liquid fuels and the electricity grid?
For plug-in hybrid vehicles, their treatment under the CTFP would essentially be split. The amount of gasoline that they consume, or liquid gasoline substitutes, would be treated as the use of a liquid gasoline or gasoline substitute. The charging, so the electricity that they take from the grid, would be treated in the same way electricity is used by a electric vehicle, a battery electric vehicle. So yes, the CTFP does account for the amount of electricity used in charging. It is true that amount is treated in the same way that a battery electric vehicle would be treated.
Okay. So let me move to the ILUC topic. You address in both your in your rebuttal testimony, and then going back to your direct testimony, the uncertainty inherent in estimating values related to ILUC due to the reasoning that these values can only be deduced by modeling as opposed to the unavailability of direct measurement, correct?
That was part of it, yes.
Okay. And I think this morning you acknowledged that since the CARB work to develop its approach to ILUC several years ago, that there have been a number of advances relating to the ILUC issue, right?
There have definitely been papers published on the topic. There have been new models or upgraded versions of the model. Yes.
And of the model, there are various models, actually, correct?
You're right. Of various models, that's correct.
Right. And there is new data available for use in the various models, right?
Yes.
Yeah. And I think your primary concern, as I understand it, is the lack of advancement of science with respect to, I think, what you referred to as subjective assumptions inherent in ILUC. Is that right?
Objection, Madam Hearing Officer. The way the question's framed appears to misconstrue the witness's testimony, so I would just ask for an instruction that the witness carefully consider what's being asked.
All right, would you just rephrase, Mr. Mullenberg?
Yeah, fair enough. Thank you. You have in your testimony, and correct me if I'm wrong, indicated that in your view, there is a lack of advancement of the science relating to subjective assumptions utilized in ILUC modeling. Is that right?
The subjective assumptions aren't really a scientific question, insofar as you can't really test to say what is the appropriate assumption to make for a lot of these. That's sort of the nature of subjectivity. Science is the attempt to create conceptual frameworks and base them on what is empirically observable. And for many of these, there isn't a scientific improvement that can be made. It is an assumption that may depend more on the values of the analyst or whoever's making it.
And as it relates to the values of the analyst or whoever is working on this issue, are policy implications inherent in the assignment of some of these values?
I don't know if inherent is necessarily the right word, but given that how a policy treats a given fuel, what level of incentive a given fuel would expect under a policy depends on the ILUC score assigned to it. And that ILUC score has a subjective kind of, non-scientific element to it, then yes, there is a strong connection there.
Thank you. Dr. Murphy, on page 7 of your written rebuttal testimony, you provide testimony in response to a party's proposal to use ILUC inputs equivalent to what would be used for palm oil for biofuels produced from other sources, meaning sources other than palm oil. Do you recall that testimony?
Yes, I believe I have that on page 8 or 9 of my rebuttal testimony, not 7, but yes, I do have that in there.
Yeah, thank you. And I have a printed out version. Sometimes the payments pages look a little bit different. But it's the last paragraph above heading Roman numeral 4. That's what I'm referring to.
Yes.
At the end of that paragraph, you present some conclusions. One of them is that substituting the carbon intensity value for biofuels based or produced using palm oil versus CI values associated with other sources would have little greenhouse gas benefits. Do you see that piece?
This is in my rebuttal testimony or my initial direct testimony?
It is, and I can read it if you like.
Let me pull that up.
Okay. Are you with me?
Yeah, I'm still here. Sorry, I'm trying to find the right phone. Why don't you go ahead and read it? I'll refresh my memory from that.
Okay, and I'll read, I'm focused on the last sentence of this paragraph, but I'll read the first part of it because that helps with the context. So I'm reading from NMED Exhibit 115, and starting in the middle of the paragraph right above your heading Roman numeral 4, dramatically overestimating the ILUC impacts of biofuels as would occur if NMED were to follow the suggestion to assume ILUC impacts equivalent to palm oil would most likely lead to very small changes in U.S. biofuel consumption. This means that adopting this suggestion would yield very little actual GHG benefit, but would substantially limit the supply of fuel for program compliance.
Yes, thank you.
Okay. So we were talking, my question related to the language little actual GHG benefit, and is part of the basis for your conclusion in that regard the small New Mexico market as indicated in your direct testimony?
That's part of it. Mostly it is because the actual greenhouse gas impacts of alternative fuels are largely determined by the amount that is produced and consumed. And so within the context of the US, federal policies generally have a larger role than state policies in setting the amount that's consumed. State policies determine where they're consumed, and they also provide more impetus for constant improvement.
Thank you. And the other part of your conclusion here is that adopting the suggestion to use carbon intensity values for palm oil for biofuels produced from other feedstocks would substantially limit the supply of fuel for program compliance. I'm wondering if you could expound on what factors are behind your conclusion that this would substantially limit the supply of fuel for program compliance.
Using those factors would essentially mean that any of the crop-based fuels any of the crop-based fuels would provide little, if any, greenhouse gas benefit. Would be credited, would generate few, if any, credits per every gallon of use. So they would not have value as a compliance option in the New Mexico market at all.
So in other words, is your conclusion related to the difference in carbon intensity values for palm oil compared to lower CI values if you were using the actual feedstocks such as, say, soybeans?
Yes, if you assigned all lipid or all crop-based lipid fuels the carbon and the ILUC adjustment factor of palm oil, then yeah, their carbon intensity scores under the CTFP would be high enough to provide little, if any, value, little, if any, credits as assessed under the CTFP.
Okay. Dr. Murphy, on page 5, you make the statement that it would be hard to justify ILUC values lower than NMED's current proposal. And I think in the current proposal, you're referring to the CARB-produced ILUC values. Do you recall that testimony?
Yes, that's correct.
And with regard to that statement, if I understand correctly, you're perhaps referring to the testimony of various parties in this proceeding, but is one of those parties that have proposed at least some ILUC values lower than NMED's proposal, NMOGA and API?
Yes, I believe those included those proposals.
Okay. So is it fair to say, Dr. Murphy, that similar to your conclusions relating palm oil, particularly that using higher CI values would limit the supply of fuel for program compliance. Wouldn't that same concept apply to the higher CI values proposed by NMED using the CARB approach in comparison to lower CI values produced using, let's say, the R&D GREET model?
Objection, Madam Hearing Officer. That sounded like a compound question and was confusing.
Dr. Murphy, if you need him to break it down, he can break it down.
No, I think I can understand the core concept, but please correct me if I'm getting it wrong. What I would say is the values proposed for the CTFP that are currently used in California have not limited the amount of fuel that's available. You can look at California, where over 80% of our liquid diesel consumption is currently made up of biodiesel and renewable diesel. The difference is the ILUC adjustment factor for palm oil is so high that any fuel that uses it essentially gains 0 credits under a program, and often would be a deficit generating fuel, means they would have to pay into the system. So there would be 0 or perhaps even negative incentive to use that within a market. At lower levels, such as those that have been more commonly discussed in this program, like the ones used in the CARB program, there is an adjustment factor. It does increase the CI of the fuels, and that does to some extent limit the amount of incentive per gallon. But clearly it is at a level that still allows very large volumes of those fuels to enter a market and derive credit under a program like CTFP.
Okay, thank you, Dr. Murphy. Those are all my questions.
Thank you very much, Mr. Mullenberg. Ms. Olson, do you have questions for Dr. Murphy?
Is the microphone on? Okay.
I can hear you just fine.
Great. Good afternoon or good morning, Dr. Murphy. It's nice to see you again.
Absolutely.
My name is Carrie Olson. I'm here on behalf of American Fuel and Petrochemical Manufacturers.
Mm-hmm.
And just to refresh our conversation from last time you were here testifying, the scope of your testimony is broadly on experience and overview of other programs and not specific to New Mexico. Is that true again for your rebuttal?
Yeah, I would also sort of include conceptual or theoretical implications, but in general, yes.
And just refreshing on some of the statements from your direct testimony, your recommendation is that a low carbon fuel standard should be focused on the fuel rather than the vehicle itself. Is that still true?
Objection, Madam Hearing Officer. I'd request that counsel tie her questions to the rebuttal testimony and not seek to elicit any further testimony on what Dr. Murphy provided in the direct case. Counsel had an opportunity for 30 minutes of cross-examination at that time, so we need to stay tied to rebuttal.
Madam Hearing Officer, I would just ask that I'm allowed to set up some background for my questions on his rebuttal, and that counsel let me explore the topics covered with Mr. Murphy for the benefit of the board to come out with the best rule that we can possibly come up with.
And my only question is, does it in fact relate to his rebuttal?
Madam Hearing Officer, I believe that the scope of Mr. Murphy's rebuttal is justifying the inclusion of ERS, and I am exploring his opinion supporting that testimony.
I remember the EER testimony.
Mr. Murphy, should I repeat the question?
Please.
Madam Hearing Officer, if I may state for the record that Dr. Murphy has not reviewed the transcript from the prior hearing. And so if any questions address what his testimony may have been, they should be to the best of his recollection.
Right. So Dr. Murphy, if there's something you don't remember or don't know, all you have to do is say so. Go ahead, Ms. Olson.
And Dr. Murphy, I'm not quizzing you on consistency with prior statements. I'm exploring your testimony. So to the extent your opinions have changed, I have a new opinion now. That's perfectly fine. Madam Hearing Officer,
Okay.
I would ask that the interruption with the objections don't count towards my time. Thank you. So I think you testified earlier, your recommendation to the board was that a low carbon fuel standard should focus on fuel rather than the vehicle itself. Is that accurate?
To the extent possible, but you can't treat it in a complete vacuum. There are some fuels that just by the nature of their characteristics and the systems that are required to handle and convert them into motion, they're going to have different efficiency levels. So, you need to understand that and incorporate that where that knowledge is available. But generally speaking, reserve as much of the treatment of vehicles and vehicle systems for policies that focus on those.
And I believe your recommendation, I think consistent with what you just said, was CTFPs can indirectly support development of vehicles with alternative powertrains, correct?
Yes, insofar as the reasons why any person would choose to adopt an alternative fuel vehicle would include the economics of the fuel they use, then yes, they do affect adoption to some extent.
And following up on the statement you just made, your recommendation is that best practice is to adopt different policies for the purpose of addressing vehicle miles traveled or vehicle efficiency.
Objection, Madam Hearing Officer. This is not within the scope of the rebuttal testimony.
Ms. Olson, can you tie it to the rebuttal?
Hearing Officer Orthis goes to the reasons and justifications for adopting an ERS program, and so I'm setting up the background before getting into the questions directly on ERS.
All right, go ahead.
Madam
Yeah,
Hearing Officer,
Ms.
can
Sullivan.
counsel point us to the record of where these statements are coming from? Are they coming from Dr. Murphy's oral testimony? Are they coming from his written testimony? It's deeply concerning me that we are circling back to direct testimony when this is for rebuttal. I understand setting the stage, but I think we know from what Dr. Murphy has said, he's providing rebuttal testimony. He's not providing enhanced direct testimony.
Okay, Ms. Olson, refresh my memory on your question just now.
Mr. Murphy just within the last 3 minutes testified about adopting different policies, and I'm following up with that question. It's also a statement that was included in his direct testimony.
Okay, so did this relate to the palm oil business, the impact on the livestock, the economic aspect of it?
No, we're exploring his testimony about efficiency of vehicles, which goes to his recommendations regarding inclusion of the ERS, which stands for energy economy ratios, I believe.
Right. Okay. So we're still talking about the
Yes.
about the ERS.
Madam Hearing Officer,
Yeah.
I don't disagree that there is content in Dr. Murphy's rebuttal testimony regarding EERs, but counsel's questions regarding his testimony several weeks ago are not appropriate at this stage. Now, if she has direct quotes, if she has citations that she can run through to set the foundation for what she's asking, that would be appropriate. But here we're just exploring stuff and asking Dr. Murphy to remember positions that he's not being asked to testify about today.
So,
Madam Hearing
so it's
Officer-
not about the technology neutrality?
She's asking specifically about testimony he provided in his direct. If it can be tied to the rebuttal, then I'll drop my objection, but that's not what's being asked.
Madam Hearing Officer, this is a little bit absurd. I think it's your role as the hearing officer to guide the scope of testimony, and I think it's fair to explore Dr. Murphy's testimony for consistency across his opinions for the board to be able to evaluate what should or shouldn't be included in this rule, and not to have NMAD be so overly strict with objections that we can't even have a comprehensive picture of what Dr. Murphy's testimony is regarding technology neutrality.
Okay, so the cross-exam today, the luxurious 15 minutes each of you has, really is just for his rebuttal. And I do remember his testimony about energy economy ratios and why they're not why it's not technology neutral when you're treating engines, right, ICE differently. So if you would explore that or tie it to that somehow and not just go back to his direct.
Well, I'm not going back to his direct. I'm going back to his advice to the board that that policies that address that best practices for policies that address specifically vehicle miles traveled and vehicle efficiency should be addressed separately outside of CTFPs, so that I can get to squaring why it's appropriate for those EERs, which are aimed at vehicle efficiency, to be included in the CTFP.
I think that's legitimate. Go ahead, Ms. Olson.
So Dr. Murphy, I think we were talking about best practices. I understand there's overlap and it's hard to create a complete fine line, but is it still your testimony that best practices are to address energy efficiencies and vehicle miles traveled in separate policies?
Yes, to the extent that it's possible, but you cannot completely divorce the consideration of the fuel from some considerations of efficiency. So, you know, a balance has to be struck, but it is not a black and white issue.
And you agree, now turning to Table 8 of NMED's revised proposal, which includes the recommended ERS values. Are you familiar with that table?
Yes.
You would agree that those are largely organized by powertrain type. Is that correct?
I don't have the table open in front of me right now. That is my recollection. It's also my recollection of how most other programs do it.
And that table lumps all vehicles which fall within that powertrain type together and assigns a single ERS value, correct?
Objection,
So when
Madam
you say
Hearing
a single-
Officer. The witness stated he didn't have the table in front of him and wasn't fully aware of what it contained.
All right. Dr. Murphy, to the extent you were beginning to answer that based on your recollection, go ahead. If you need to pull up the table, do that.
So I recall, you know, categories, for example, electricity used in light duty vehicles, or electricity used in a medium or heavy duty vehicle, or natural gas used in a heavy duty vehicle. So if that's what you mean by categories, then yes, that is how the EERs typically work.
And the benefit of the EER is the same benefit of EER is assigned across the entire powertrain type. Is that accurate?
Yes,
So
they're based on averages. And so the analysis done to establish the EERs considered the average across that category or type.
And there's no consideration in energy efficiency across vehicle types that fall within that powertrain type. Is that accurate?
There is, because it's based on the average. So the efficiency of more efficient vehicles is included in the average along with the efficiency of less efficient vehicles. That's how you arrive at an average.
But it's not based on the efficiency of any given vehicle in that. It's based on an average that's categorically applied to powertrain type.
Yes.
And you would agree with me that fuel efficiency varies widely across ICE vehicles, correct?
It does, but you can't have EERs for individual vehicles. The complexity, the administrative burden is impossible, and there's really no way for a pathway holder, which is usually the producer of an alternative fuel, to know which vehicle their fuel is going into. So averages across categories are really the only practical way to do it.
And you're familiar with regenerative braking?
Yes.
And you would agree that some hybrid vehicles can use regenerative braking to generate fuel for running the vehicle, charging the battery and relying on that battery to extend efficiency?
Yes, that's true, and that effect is included in the calculations underpinning the EERs.
Well, isn't it true that hybrid vehicles are categorized the same as ICE vehicles in the EER value table?
Yes, but for a hybrid vehicle, this is a non-plug-in hybrid vehicle, so one that only uses a liquid fuel as a primary energy source. Even with the effect of regenerative braking, you still arrive by testing it over efficiency test cycles at a fuel economy value. That fuel economy value includes the impact of regenerative braking.
So that energy economy value includes the value of regenerative braking for ICE vehicles that have no regenerative braking.
Madam Hearing Officer, I'd like to object to the extent of the line of questioning regarding regenerative braking. This is nowhere within Dr. Murphy's testimony. He hasn't talked about different fuel train types. I understand the follow-up of why she's asking, but it's going deeper now.
Okay, this goes to the neutrality of the technological review.
That's correct.
Yeah, that overruled. Go ahead, Ms. Holt.
So I remember the question. A vehicle that does not have regenerative braking is going to get no efficiency benefit out of the regenerative braking system that it doesn't have. So yes, the regenerative braking is considered in the value in the EERs or in the fuel efficiency value used to calculate EERs for ICEs. It's just that value is zero, but it's included there.
So do you agree that the EER values in Table 8 aren't intended to accurately reflect actual efficiencies of a vehicle?
Again, the EER is a ratio of the efficiency of the advanced technology or advanced fuel vehicle to the conventional vehicle. Those underlying ratios, the efficiency of either the advanced or the conventional, are meant to be the best possible science available on that value. Certainly you can nitpick and say that maybe value needs to be updated or should be higher or lower, but they are included. It sounds like you're trying to get me to say that there's some significant element missing from the EERs, and certainly that's not the sense I get. They are an attempt to be as comprehensive and accurate as possible, an estimate of the relative efficiency of one powertrain to another.
So is your testimony that the relative efficiency of a hybrid vehicle with regenerative braking is the same as an older ICE vehicle?
No, but the enhanced efficiency of a hybrid vehicle is included in the average. So the average they used as the comparison, as the reference fuel, included an average of all vehicles in the fleet, including hybrids that are more efficient and older vehicles that are less efficient.
Okay. I want to move on very quickly to touch on some of your biofuel testimony. So I think at the end of your rebuttal testimony, you mentioned generically that other policies can affect biofuel consumption. Is that correct?
That's true, yes.
And I believe your opinion earlier, correct me if I'm wrong, is that in most existing programs, the majority of compliance occurs by purchasing credits.
That's correct.
And is it also your testimony that that greater utilization of lower carbon alternative fuels is dependent on the availability of those lower carbon alternative fuels?
Yes.
So when we're looking at policies that influence biofuel consumption and biofuel availability, are you aware of the New Mexico biodiesel mandate?
Not in specifics, but I'm generally aware of the existence of one.
And if there's a lack of availability of biofuels in the state, would it be reasonable to assume that it can take several years to address that availability before that can be a viable credit source?
Well, it depends on what the reason for lack of availability is. If there is a pool of fuels in a relatively close market, or at least a market where there are strong links and ability to transport, then the lack of availability in one market can be remedied more or less as quickly as it would take to establish the contracts and move it over. In New Mexico's case, given that there is a approximately 5 to 6 billion gallon a year market for biomass-based diesel substitutes in North America, there is more than ample supply of fuels available that could very quickly be brought into New Mexico. As long as the incentive remains to bring it.
Madam Hearing Officer, may I request a time check, please?
Yeah, you have about 2 minutes.
Okay. Mr. Murphy, if New Mexico was unable to achieve the existing biofuel or biodiesel mandate due to lack of availability, would that change your analysis about how quickly the fuels could be available in New Mexico?
Objection, Madam Hearing Officer. The witness testified that he was only very briefly aware of what that mandate is. To ask him to opine on compliance with that mandate is beyond the scope of what he testified he can discuss.
All right. So, Dr. Murphy, if you don't know the answer, that's fine. You can just say that.
Yeah, I would have to look at the specific biodiesel mandate. It is difficult for me to envision a set of conditions under which the CTFP would make it impossible to satisfy the biodiesel mandate.
One more question.
I guess one final question is, if, just hypothetically assuming as an expert, that those fuels were not currently available to be an immediate credit source for this program. Is it your testimony that it could take a couple years to build that credit market for biodiesel and biofuels?
Objection, Madam Hearing
Yes.
Officer. At the beginning of the testimony, Dr. Murphy agreed that the scope was not to discuss specifically what the New Mexico market was. He was talking high level. If council could clarify whether this is high level policy or New Mexico, that would be appropriate.
All right, Dr. Murphy, if you need clarification, just ask for it.
I would say if you assume that you can't satisfy the mandate, then of course you can't satisfy the mandate. But there is no reason to believe, given the existence of a very large pool of biomass-based diesel substitute production in North America, that New Mexico would be unable to satisfy the mandate. So it seems like the assumption you'd have to make to arrive at that is assume a very different world than the one we live in.
And I believe before we got interrupted, my question might have gotten lost in there. I was asking you to assume we don't currently have the availability of fuels. Is it your testimony it would take a couple years to build that availability through permitting, financing, construction, and commissioning?
Objection, Madam Hearing Officer. During the direct case, we established that speculative questions were not permissible.
Madam Hearing Officer, he's here testifying as an expert. It is common to ask experts to opine based on their expertise. If he wants to say he doesn't have expertise, that's fine.
Right. So, Dr. Murphy, if you're comfortable speaking about speaking in answer to that question, go ahead. If it requires more speculation than you're comfortable with, just say so.
Again, I would just say, if you assume the supply didn't exist, then yes, it would take a couple years to build additional commercial scale supply. However, in the case today, the supply exists.
Thank you, Dr. Murphy. Those are all the questions I have for you. Appreciate your time this morning.
All right. Thank you, Ms. Olson. Let's break until 1. When we return at 1, we'll take public comment, then we'll return to the questioning of Dr. Murphy.
For council, if you would mind sharing whether you're going to to his meeting. We were hoping to finish by lunch, and he has other commitments. So if we could just help him estimate, I would appreciate that.
Are we still on the record? Because I could not hear Ms. Sona.
We're off the record, David. Yes? Okay. Good afternoon. We are back after a lunch break, and we have reached one of our public comment sessions. This is the first of 2 public comment sessions today. We'll have another one at 6 p.m. tonight that will be virtual. The link is on the Docketed Matters page. My name is Felicia Orth, and this is EIB 25-23. Clean Fuels Transportation Program. Just a couple of things about public comment. I will ask you to spell your first and last name for the transcript. I will ask if you swear or affirm to tell the truth pursuant to the board's rules. I will ask you to speak slowly so that, again, the court reporter can capture your words as well as the interpreters. And I will ask you to keep your comments to 3 minutes. If you have more than that to say, please put it in writing sometime by Friday and send it to Pamela Jones, the board administrator. Lisa, would you please make a statement for the Spanish speakers?
Buenas tardes. Si hay alguien aquí presente que quisiera dar un comentario público, sí pueden avisarnos y con mucho gusto le interpretamos al inglés. If there's anybody online who would like to make a public comment, please let us know via the chat. Si hay alguien que quisiera dar un comentario público que está en línea, por favor déjenos saber por medio de chat.
Thank you very much, Lisa. Is there anyone in the room who would like to offer public comment during this session? Please raise your hand. I thought we had someone. Okay. Oh, there you are. Make sure the microphone is on. Seems like it's on. Who would state your first and last name?
Sure. Give me just a minute. Okay, good afternoon. I'm Camilla Feibelman. I'm the director of the Sierra Club's Rio Grande chapter.
And would you spell your first?
Sure. It's Camilla, Camilla, and the last name is Feibelman, F as in Frank, E-I, B as in boy, E-L-M-A-N.
Okay. Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Thank you. First, thanks to you and to the members of the Environmental Improvement Board for doing this extensive hearing. I'd like to make a few requests as we get towards the end of this rulemaking. The first is no bonus credits for methane. Don't pay for more pollution. The proposed rule is considering giving the fossil fuel industry lavish subsidies for its methane that it could generate even more credits than truly clean resources like electricity from wind and solar. The program should not include avoided methane credits. Number two, let's make sure that the rule recognizes efficiency. The proposed rule appropriately recognizes that some technologies are more efficient than others through the inclusion of EERs. The board should absolutely include those and they should remain part of the rule. Let's recognize the benefits of public transit and let's allow public transit agencies to earn credits for the work that they do to reduce emissions by moving people more efficiently. Let's focus on fuels that have real benefits. The board must not allow industry to take credit for supplying fuels it characterizes as clean, but that have far-reaching adverse environmental and economic consequences. In particular, crop-based fuels often lead to deforestation and increased fuel prices. Land should be for food, not for fuel. And let's keep these benefits in New Mexico. The board should eliminate book and claim accounting so that the rule supports clean transportation in New Mexico, not allowing out-of-state suppliers to take credit for work they're doing elsewhere, especially in the light of the profound dissolution of climate action at the federal level. We need these rules to be as strong as ever. Thank you so much.
Thank you, Ms. Feibelman. Oh, yes. Would you be willing to answer a question from the board now?
Sure.
Just real quick, Ms. Feibelman, did you submit written comments as well?
You know, I haven't yet, but I can by the deadline.
Thank you.
Sure thing.
Is there anyone else in the room who would like to offer comment during this session? We'll have another session at 6 p.m., another session at 1 o'clock each afternoon, so long as we remain in hearing. No? All right. I believe we have someone on the platform. Varun Iyer. Can you unmute yourself? Hello.
Hi, my name is Varun Magesh Iyer. I'm a research affiliate of the Regulation, Evaluation, and Governance Lab at Stanford University.
Would you please spell your first and last name?
V-A-R-U-N, N as in Nancy, I-Y-E-R.
Do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your time.
Researchers, first of all, thank you for conducting this hearing. Researchers at RegLab and the Center for a Livable Future at Johns Hopkins University recently completed an extensive project examining a key question in the proceeding. Do avoided methane credits create perverse outcomes by driving farms to expand their livestock operations? Based on our observation of dairy farms in California—
Hold on, Mr. Iyer, I'm very sorry to interrupt. If you would, I think maybe because you're moving your head a lot, you're breaking up. And you're also speaking a little too quickly for us to capture the transcript. So just slow down. Thank you.
Yes. Thank you. Is my voice coming through better now?
What? Oh, if you turn off the video, I
Yes.
think we'll be able to hear you better.
Is this any better?
It is. Thank you.
Okay. Thank you. Based on our observation of dairy farms in California, we found that methane crediting does lead to an increase in herd size. Farms planning a digester grew by an average of 860 more cows than similar non-digester farms over 3 years. I'll be filing this comment and a copy of our working paper sharing the finding for entry into the record for consideration by the board. I want to share a few more about the specifics of the study and the methods that we used to make sure that we were able to see the effect of digesters alone, separate from other factors like pre-planned growth or nationwide consolidation trends. We started by looking at all 134 farms in the state that began planning digesters after the crediting policy was announced. Using statistical matching, we paired each non-digester farm with a farm having each digester farm, with a non-digester farm having similar herd size and infrastructure beforehand. This ensured that we compared apples to apples, capturing the effect of digesters and not nationwide consolidation trends. We analyzed nearly 9,000 satellite images of digester and non-digester farms taken between 2016 and 2025. We hand-labeled each image to track infrastructure expansion on the farms and compared expansion at farms that got digesters with matched farms that didn't, and using methods that allowed us to account for the fact that farms started planning their digesters at different times. This approach helped us isolate the actual effect of digesters on farm expansion rather than other factors like nationwide consolidation trends. We found that digester incentives increased herd size. Before planning digesters, both digesters and non-digester farms grew at identical rates. After the planning began, digester farms diverged sharply. In 3 years, farms that built digesters grew by an average of 860 more cows than non-digester farms. Using established emissions measurements, we estimate that enteric emissions and leakage, digester leakage from the additional cows undercut a third of the claimed reductions of the policy. Farms will likely continue accelerated growth beyond the 3-year window, further eroding climate benefits. Our work shows that the crediting program overstates emission reductions by subsidizing the expansion of the largest industrial dairies in California. The conclusion that we find is unsurprising. When farms make more per animal, they get more animals. On page 8 of his written testimony, Dr. Colin Murphy stated that the causal link between ETFP incentives and negative environmental outcomes has not been demonstrated with enough magnitude or significance to justify restrictions to methane credits. Our research demonstrates this link. We provide causal evidence that avoided methane incentives drive herd expansion, and that the expansion is large enough to negate a third of the program's claimed reductions in just 3 years. Thank you for your attention to this issue, and I'd be glad to answer any questions from the board as well.
Thank you very much, Mr. Iyer. Do board members have any questions? No. Thank you. Riley Bradshaw?
Yes, thank you.
Hello. Would you spell your first and last name, please?
Yes, it is Riley Bradshaw, Bradshw.
Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. I'll start your time.
Good afternoon. My name is Riley Bradshaw, and I'm here today testifying on behalf of the Love's family of companies, which include Love's Travel Stops. Love's is proud to operate fuel retail and travel center locations across New Mexico. We are also a member of Americans for Affordable Clean Energy, known as Double ACE, which will also testify during these proceedings. We are one of the largest biofuel blenders in the United States, active in blending both renewable diesel and ethanol into gasoline. We have ample experience leveraging LCFS-type programs to offer consumers lower-cost fuel that has more favorable emission characteristics than our competitors. We are eager to bring this policy and marketing understanding to this conversation. We support the goals of the Clean Transportation Fuel Program and believe that if implemented clearly and consistently, the program can help New Mexico reduce transportation emissions while maintaining affordable, reliable fuel supply for consumers. So, our testimony today focuses on an important definitional issue that remains unresolved in the most recent public draft. The definition of regulated party in section 20.2.92.7 is potentially misleading and could lead to conflicting interpretations. This definition outlines which entities generate credits and deficits, meaning that even perceived ambiguity can create significant and avoidable confusion in the marketplace. That uncertainty would make it more difficult and more expensive for market participants to bring lower carbon intensity fuels into New Mexico. If a company owns retail gasoline or diesel fueling stations, that alone should never compel the company to accrue deficits under the CTFP. This is how other state LCFS programs work in California and elsewhere, and it is how the federal renewable fuel standard works. So, the program already provides clear and satisfactory definitions of regulated party for each energy technology in sections 20.2.92.401 through 403. Those sections make it unambiguous who holds the compliance obligation for each fuel type. As a result, the general definition in section 20.2.92.7 is unnecessary and risks creating confusion where the fuel-specific provisions are already clear. We therefore encourage the board either to remove the superfluous definition in section 20.2.92.7, or at a minimum, to clarify that the definition in no way alter or expands the meaning of regulated party as applied in sections 20.2.92.41 through 403. As made clear in the testimony of Borough Chief Borchert of the New Mexico Environmental Department, fuel retailers, marketers, distributors, and fuel dispensers are not intended to be regulated parties under this program unless they are also refining or importing fuel into the state. This regulatory text should further reflect that Chief Borchert's testimony applies to both diesel retailers and gasoline retailers. This point should be unambiguous in the regulatory text. It is currently ambiguous. This threatens to create real compliance and cost challenges. If market participants fear that downstream entities, including retailers or fuel dispensers, could be construed as regulated parties for liquid fuels, that uncertainty will result in market disrupting consequences. It could also create inconsistencies with other state clean fuel programs, all of which assign deficit obligations exclusively to producers and importers of liquid fuels. We appreciate the substantial work the Environmental Improvement Board and the department have devoted to developing this program. We believe these limited technical clarifications will promote regulatory certainty and help ensure that the program supports low-cost, low-carbon transportation energy in New Mexico. Thank you for the opportunity to testify today and for your work on this important matter.
Thank you, Mr. Bradshaw. Is there anyone else in the room or on the platform who'd like to offer comment at this time? Our next public comment session will be at 6 p.m. That will be a virtual one. And then the one after that will be 1 o'clock tomorrow. Oh, Pam, anything? All right. Thank you, Pam. Let's go back to the technical case then. Dr. Murphy, I think I saw you on the platform. Dr. Murphy, can you join us with your camera?
I can see Dr. Murphy.
Let's see. Okay. There we go. Shall we do a sound check, Dr. Murphy?
There we go. All right, now I can unmute. Thank you.
Terrific. Thank you. Let's see. When we broke, Ms. Olson, I think, had just finished. Mr. Tucker, do you have questions of Dr. Murphy? Thank you. He said no. Mr. Boutier or Mr. Harris?
No questions.
Thank you. He said no. Mr. Maxwell, any questions?
No questions.
Thank you. Mr. Weatherby, I don't know if we have him with us or not.
No,
All
no
right.
questions, Madam Hearing Officer.
Thank you. I don't know if we have Ms. Tremblay for Southwest. No. Ms. Veracruz? She said no questions. Mr. Sorayas or Mr. Wade?
No questions. Thank you, Madam Hearing Officer.
Thank you. Mr. Lobdell?
Thank you, Madam Hearing Officer. I do have a few questions for this witness.
Thank you.
Great. Madam Hearing Officer, Madam Chair, board members, and Dr. Murphy, good afternoon.
Good afternoon.
I only have a few lines of questions for you, and I'll be focused on your testimony under Roman numeral 4 in your rebuttal regarding the impact of proposed CTFP on livestock herd size. And so that's on page 7 to 8 of your rebuttal testimony, Dr. Murphy. So I'll direct your attention there. I'm going to try to quote your words as much as possible. So in about the middle of that first paragraph, you state that, quote, "It is certainly plausible, perhaps even likely, that avoided methane credits do incentivize larger herd sizes. However, this effect appears to be significantly smaller than other economic forces in the livestock industry." Did I get that correct?
Yes, that's correct.
Okay, great. I'd love to just take that sentence in its two parts. Can you, Dr. Murphy, just say a little bit more about what you mean by, quote, "perhaps even likely that avoided methane credits do incentivize larger herd sizes"?
Well, at the conceptual level, the basic economic relationship of when something becomes more valuable, you tend to see more of it, that exists. And there are known economies of scale in the production of renewable natural gas from digesters at livestock. So there is a kind of good conceptual argument that says we would expect to see force pushing towards consolidation from those. But when you attempt to sort of isolate that effect or correct for the other factors that are affecting the space, sort of broad industry consolidation trends, it doesn't look like you get the magnitude of the effect from the kind of pro-consolidation things from the herd size and the economies of scale seems to be significantly less than the effect of all these other broad economic trends that are out there.
Thank you, Dr. Murphy. Well, you led us directly into my second question, so I appreciate that. Can you explain what you mean by, quote, "significantly smaller"?
So I have not personally done a quantitative analysis. I'm relying on analyses done by others in this space. But I guess probably the best way to say it is, I think it is likely we would see very similar trends on herd size, even if avoided methane credits did not exist. Avoided methane credits in clean fuel programs like the California LCFS or the one proposed in CTFP.
Okay, thank you. Just so I understand your testimony, you're not equating significantly smaller to insignificant. Is that correct?
That was certainly not the intent nor the way I wrote it. It is possible they could be insignificant, but all I can say with any confidence is it's likely that they are significantly smaller.
Thank you, Dr. Murphy. In your expert opinion, would you consider a deviation of 500 mature dairy cows to be a significant expansion?
It depends on the scope of the herd we're talking about. 500 cows in, say, the scope of California? No. 500 cows in the scope of one dairy. If that was found to be a consistent result across multiple dairies, then probably yes.
I see. Would your response be the same if I changed that to 700 head deviation?
No, it would be the same. I'm sorry. Yes,
Okay.
it would be the same. It would not change.
Okay, thank you, Dr. Murphy. Are you aware that the US EPA's regulatory definition distinguishing the threshold size for a large concentrated animal feeding operation versus a small one is 700 head of mature dairy cows?
I was not aware of that, no.
Okay. Do you have any reason to disagree with that?
You know, my expertise is not deeply on dairy size or economics. When I use the term significant in my testimony, it was really whether the incentives provided by clean fuel programs make a meaningful change in the conditions on the ground.
Got it. And meaningful in your interpretation here is sort of hitched to the other dynamics and their magnitude. Am I getting that right? Okay.
Yeah.
So in other words, under your analysis, impacts or the results could be significant, but your expert opinion is that there are other factors that are just significantly have a significantly higher magnitude, and therefore those less significant impacts should not be considered, or should not see policy guardrails in response.
Yeah, certainly. I don't think the significance of this impact is enough where, based on the evidence we have and has been presented right now, a change in policy needs to be made.
Okay, thank you. And am I right to read your testimony as relying on NMED's Exhibit 116 or footnote 8 in your rebuttal testimony as sort of the underpinning for this this assertion that it is significantly smaller?
That is one of the sources. That source, I believe, footnote 8 is the blog from Aaron Smith.
That's correct. That's correct, Dr. Murphy.
Yeah, that is one source that has what I think is sort of the best, the most well articulated summary, but it's certainly not the only source that I've seen in this space that leads me to my opinion. Okay.
I'm going to change tack a little bit further down on that same page 7. You discuss some of those other larger market trends, and you identify returns to scale from automation and consolidated processing infrastructure. When you say, what do you mean by consolidated processing infrastructure?
Just that generally speaking, labor is one of the kind of most expensive elements of the production of milk and dairy, and generally speaking, you need less labor per unit of production on a larger facility than on a smaller one. There are other economic drivers of this as well, but there are a number of factors that have been leading toward consolidation in this space. Even before clean fuel standards and the potential subsidies from avoided methane were in place.
Okay. Dr. Murphy, in your expert opinion, just in your experience or in your research, would you agree that manure biogas production also benefits from consolidated infrastructure, for example, an upgrading facility or a pipeline interconnection point?
Yes, when I mention returns on scale, that is exactly what I meant.
Okay, so you agree then that incentivizing biogas production shares some of these dynamics that you're identifying as extant, but could also be intrinsic to the proceeding in the conversation here.
I'm sorry, could you repeat the question?
Of course. So it sounds like you're agreeing that some of these trends that you've identified as broader market trends also apply within the context of incentivizing manure biogas production.
Yes.
Okay, thank you. All right, and I just want to briefly turn to NMED's Exhibit 116 that we've already discussed briefly. That's Aaron Smith's. You characterized it as a blog. Is that correct, Dr. Murphy?
Yes.
Okay, thank you. In your opinion, what's the conclusion of Mr. Smith's blog?
Similar to mine, that the effect is clearly there, but it is largely other trends that are driving the broader dynamics in the dairy space.
Got it. Thank you, Dr. Murphy. If I can draw your attention to page 6 of that exhibit, so NMED Exhibit 116, at the bottom of that page, a quote, "Data from the 2022 census will enable us to see whether the number of cattle on large farms has increased during the digester boom, but it will not be released until next year." End quote. Dr. Murphy, are you aware of what census that's referring to?
I believe it's the USDA agricultural census, which is sort of a large-scale data collection and dissemination exercise carried out by USDA.
Great, thank you. And do you know the time frame of that latest USDA census that would have ended in 2022? Like when that?
I do not.
Okay. Do you believe that, well, I'm sorry, do you recall when the California Low Carbon Fuel Standard implemented avoided methane crediting for manure biomethane?
I'm trying to remember if it was in the initial policy design or if it was included in the 2016 readoption. I know it has been in place since at least 2016. It's possible it goes back to the very start.
Okay, and I don't want you to speculate, Dr. Murphy, so that's totally fine. Would a data set starting in 2017 through 2012, or I'm sorry, 2017 to 2022, would you agree that that would be especially relevant if avoided methane crediting was introduced in 2017 to the California program?
Objection, Madam Hearing Officer. Questions regarding the details of an exhibit for the purpose that that exhibit was not offered, I do not believe are within the scope of Dr. Murphy's testimony.
Dr. Murphy, I'm not sure if you can answer the question. If it is beyond your experience or expertise or requires speculation, you can just say that.
That would require speculation.
Okay, understood. Last question for you, Dr. Murphy, or last couple of questions here. Well, actually, back to Mr. Smith's blog, one more question on that. Would you agree that this statement that I just read, the data from 2022 census will enable us to see ... but it will not be released until next year. Would you consider that a data limitation for that analysis?
I mean, I would consider it a data limitation. I would not interpret it as meaning once the census comes out, we will have a conclusive and, final definitive answer. But certainly that it is a significant milestone in data release that'll let us understand these dynamics.
Fair enough. Would a analysis that did not have that limitation potentially be more reliable, do you believe?
Objection, Madam Hearing Officer. The question calls for speculation.
Okay. I'll withdraw the question, Madam Hearing Officer. Right. Okay, so last question. I know I'm short on time here, Dr. Murphy. I really appreciate you and your time. I know we've kept you. Were you able to hear the public comment session that just took place?
Yes.
Okay, and I'm not going to ask you to opine on any of the substance. One of the commenters, Mr. Iyer, presented some findings that they've conducted through research. I'm not going to ask you to opine on any of that substance. I presume you haven't had a chance to look at it. But in your rebuttal testimony, you sort of end on this issue by noting that, quote, "further research into this topic is likely," end quote. From what you did hear from the public commenter, Mr. Iyer, is that the kind of research you were alluding to when you finished this section in your rebuttal testimony?
It would likely be a study that I would be interested in seeing. It would likely contribute to understanding in the space. Again, without knowing anything about the details of the study, I can't say how much weight it would provide or if it would change any conclusions.
Thank you very much for your time, Dr. Murphy. Madam Hearing Officer, I don't have any further questions.
Thank you, Mr. Lobdell. Mr. DeSalen, any questions for Dr. Murphy?
Yes, Madam Hearing Officer. Ms. Gerson will be conducting the cross-examination of this witness. I believe she is on the platform.
Thank you. Ms. Gerson, can you unmute yourself?
Yes. Good afternoon. My name is Sarah Gerson, and Dr. Murphy, I'll reintroduce myself as an attorney for the Coalition for Clean Affordable Energy, or CCAE. And I will start by picking up just where Mr. Lobdell left off, with some questions about Department Exhibit 116, which is the blog post of Aaron Smith. Would you agree that Aaron Smith is a very well-respected economist?
I'm not exactly sure how to answer that. He's a former colleague of mine at UC Davis. He's tenured professor, but well-respected. I don't know exactly how to answer.
Okay, I'll move on. He explains in the blog post the incentives at play with a concept that he refers to as the Cobra effect. Could you please explain what the Cobra effect is?
Objection, Madam Hearing Officer. Sorry, I've been told by the platform that there is a little bit of a delay between what they can hear and when I object. So I apologize to folks if I accidentally cut you off. As we established previously with Council for Food and Water Watch, unless the contents and questions about the exhibit are tied to the basis for which it was used, and if council can set a foundation for that, it's an appropriate question. Otherwise, it's outside the scope of the testimony that Dr. Murphy is offering.
Ms. Gerson, can you tie this up?
The Cobra effect is something that Dr. Smith discusses in the context of discussing the impact of biomethane incentives on herd size, correct?
Sorry, are we still on the objection, or is that a
No,
question
no.
for me?
If this was in your testimony, please go ahead.
Okay.
So the question is, can you just
rephrase,
please explain what the Cobra effect is?
It comes from a British policy in colonial India offering rewards for to bring dead cobras as a safety measure, and as a result, in some cases, people would start farming, ranching cobras in order to expand the number they collect.
So essentially, if you pay someone a lot of money for something, you tend to get more of that thing, right?
Yes.
And this incentive structure could encourage livestock owners to produce more methane, not just by increasing the size of their herds, but also by doing things like heating up manure lagoons, correct?
Yes, that is conceptually possible. I'm not aware of any evidence of that occurring, but okay.
Okay. So big picture, is it fair to summarize your opinion on this issue by saying that you think that avoided methane credits can incentivize larger herd sizes, but other economic forces are bigger drivers of herd expansion?
Yes.
Would you also agree that aside from the biomethane incentives in this rule, that those other larger factors driving herd size expansion are generally outside the control of this board?
Without knowing the details of New Mexico's legal and administrative context, I don't know what the jurisdictional scope of this board are. Most of the factors driving herd size are outside the scope of alternative fuel policy.
Okay, thank you. Did you review the portions of Dr. Cheryl Laskowski's direct testimony where she raised concerns about avoided methane credits?
Yes, it was some time ago, though.
Okay. Have you reviewed the rebuttal testimony of the other department witnesses in this case?
Parts, but not all.
The parts related to biomethane incentives?
I certainly cannot guarantee I've reviewed all of it. I have looked at some, but for the most part, the testimony of others was left to them.
Okay. Well, to the best of your ability, can you confirm whether you address the following concerns of Dr. Laskowski, and if you don't, direct me to any department witnesses that do cover these concerns? First, did you, or to your knowledge, anyone else in the department's rebuttal case address the concern that New Mexico would pay for credits from out-of-state biomethane that yield little or no in-state benefits?
Objection, Madam Hearing Officer. Council can deal with this through their own witness. It's not appropriate to ask a witness who's already stated very high level infamiliarity with the rest of the record to characterize the record of Ms. Gerson's client and of his co-witnesses.
So, Ms. Gerson, does this relate to Dr. Murphy's rebuttal testimony?
Yeah, I'm just trying to identify which concerns about the perverse incentives created by avoided methane crediting Dr. Murphy addresses, or if they go unaddressed in the department's rebuttal case.
Madam Hearing Officer, council can read the case. I'm
Yeah.
sorry.
Yeah, I'm not sure why this would be your cross-exam at this point, knowing what Dr. Murphy's rebuttal testimony is, and then having the ability to know what the other panelists' rebuttal testimony is going to be. Is this a good use of the time?
All right, I'll just move on and follow up on a portion of your rebuttal testimony that you were discussing with Mr. Mullenberg. So specifically in your rebuttal to the recommendation to apply the ILUC value of palm oil to certain other feedstocks, you opine that following that recommendation would substantially limit the supply of fuel for program compliance. Do you recall that?
Yes.
Did you watch parties cross-examine Dr. Laskowski on this recommendation at the previous hearing?
Objection, Madam Hearing Officer. It's inappropriate to ask the witness to testify about what another witness has testified about.
Well, we don't know yet where she's going. Ms. Gerson, are you going to ask if he agrees with something related to his rebuttal that Dr. Laskowski testified to?
Well, he is rebutting her recommendation, and I want to make sure that he fully understands that recommendation and heard her speak about it at the hearing.
All right, that's fine. Go ahead.
No, I did not have the opportunity to see her testimony at the last hearing.
Okay. Are you aware or understand that her recommendation would not affect the carbon intensity value of biofuels produced from waste feedstocks, such as used cooking oil and tallow?
I wasn't aware of that. Even if that were the case, the supply of those is very limited. And so I would need to do a significant amount of modeling to figure out whether the available supply of waste and residue feedstocks is sufficient to meet New Mexico's needs for alternative fuel, in coming years.
And have you performed such an analysis?
No.
And so consequently, is it fair to say that you haven't done the modeling that would be necessary to understand whether CCAE's ILUC recommendation would have a significant impact on program feasibility or cost?
That's true. That's correct.
Thank you. In the same paragraph of your rebuttal testimony, you testify about how the federal renewable fuel standard essentially determines how many gallons of biofuels are consumed in the United States as a whole, correct?
It plays the most significant role of any policy out there. Essentially determines, might slightly overstate, but it's by far the biggest impact and largely determines the amount of biofuels available in the North American market.
Okay. So consequently, is it generally true that the opportunity to generate CTFP credits for soy-based renewable diesel doesn't significantly reduce aggregate global greenhouse gas emissions?
The opportunities to generate credits in CTFP from soy doesn't significantly reduce global greenhouse gas emissions.
Madam Hearing Officer, I'd like the record to reflect that the witness was simply thinking and repeating the question, not testifying at that moment.
I thought that was clear. Thank you. Go ahead, Dr. Murphy.
Again, without having the ability to do the modeling, it's hard to say. I would say that is likely to be true. The difference is if all crop-based fuels are given the same ILUC value, given the ILUC value based on the palm ILUC adjustment from CARB's assessment, then none of these fuels would generate any real credits under the proposed CTFP, and that could lead to problems, with compliance. So, because the contribution of CTFP to global volume production is likely to be, probably minimal, there's not going to be a major global greenhouse gas impact either way. The question is, are the fuels that are already being produced in the US market available to New Mexico to provide compliance credit?
Okay. And in my final question, I hope it's my final question, I'd like to contrast that with the dynamic with incentives for electric fuels. So do you think it's fair to say that if state incentives help New Mexico's families and businesses transition from petroleum vehicles to electric vehicles, that can, in fact, provide climate benefits from a global perspective?
If those incentives were in additional to what would have happened otherwise, then yes. I don't know if they are large enough to be considered significant in a global standpoint. Again, that would take modeling.
Okay. Thank you, Dr. Murphy. I have no further questions.
Thank you, Ms. Gerson. Mr. Smith, do you have questions? Mr. Duff? Yes?
Mr. Smith is rejoining the meeting.
Oh, all right. Okay. I don't think we have Mr. Nasco anymore. Mr. Noyes?
Thank you, Madam Hearing Officer. No questions.
All right, thank you. I'll call on Mr. Smith again. Mr. Smith? Do you have questions of Dr. Murphy?
It looks like from the chat he's on the same microphone as Donna Belcher, and they are asking for the mic to be allowed to be unmuted.
Pam is saying they have permission to unmute.
Okay, sorry about that. Yeah, we're trying to get to unmute Donna because I'm on another call on the other screen. So I appreciate the time. So Dr. Murphy, earlier was mentioned about the mandate that has been suspended for the last 12 years in the state of New Mexico. One of my questions was, are you aware of why that was suspended for the last 12 years on every 6 months?
Objection, Madam Hearing Officer. We've established extensively that this witness's scope of testimony is not unique to New Mexico, and he previously testified as to his knowledge about that mandate to say he really has no knowledge. And so this line of questioning is inappropriate given the previous testimony and orders.
So, Mr. Smith, you may have missed Dr. Murphy's earlier testimony. He really is aware of that mandate, but doesn't have any specific information about it.
Okay, the other question I had was, does he know what resources or information the state used for just suspending that every 6 months?
Same objection for the record, Madam Hearing Officer.
Overruled. Go ahead, Dr. Murphy.
No, I do not.
That's all I have. Thank you.
All right, thank you. Ms. Sona?
All right, thank you, Dr. Murphy, for being with us this morning and through lunch. I have just a couple of redirect questions for you.
Okay.
Actually, Madam Hearing Officer, did the board have questions? Or are we doing board questions after? Okay, thanks. It's been a long day already. Dr. Murphy, is the extent of your knowledge about the New Mexico biodiesel mandate that it exists?
Yes, certainly specifically. I'm aware of similar mandates in other states, but beyond that, all I know is New Mexico has one.
And I hear Miss Sona.
Yeah, I lost audio from the room as well.
Madam Hearing Officer, Counsel for NMED has extensively objected to questions about it. I think it's inappropriate for her to ask on redirect to reopen this line of questioning.
And
she can't have it both ways.
All right, thank you, Ms. Sona.
You overruled my objections, Madam Hearing Officer, so I do believe it is appropriate.
All right, go ahead.
Dr. Murphy, you are not an expert on how the New Mexico biodiesel mandate is applied, correct?
That is correct.
Okay. Is a carbon intensity about, when we're talking about EERs, is a carbon intensity about the fuel versus the vehicle, or is it about the wheel-to-well emissions of the fuel?
It's about the well-to-wheel emissions of the fuel.
Thank you. And there is not a robust scientific basis for a palm oil only ILUC, correct?
No, there is not.
And hopefully last question for you. Does C Club make optimistic, subjective assumptions that contribute to a lower ILUC value?
I certainly think so. If you compare C Club to other models in the space, as the EPA intermodal comparison did, you'll see it's at the low end of the range pretty uniformly.
Thank you, Dr. Murphy.
All right, thank you, Ms. Sona. Member Ely, would you like to ask questions?
I have no questions at this time.
All right, thank you. Madam Chair?
No questions at this time either.
All right, thank you. Member Garcia on the platform?
I just have one quick question. Can you hear me okay?
Yes.
Yes.
Okay, thank you, Dr. Murphy, for your testimony. A couple of the questioners sort of danced around the topic of this rule possibly creating a perverse incentive for increasing herd size, et cetera. And you mentioned that there may be other economic factors that play a larger role in a business making a determination whether to increase herd size. Could you expand on that? And I know that you're not familiar specifically with New Mexico, but could you expand on what some of those other factors are? Could you list some of them besides labor cost? You mentioned labor cost, but what are some of the other factors?
Yeah, I think generally speaking, we've seen a trend towards consolidation across most industries and business types in the US over the last 20 to 30 years. Some of this has to do with tax treatment and the way that, labor versus capital is treated on tax records. Some of this has to do with sort of marketing and the power of large marketing and distribution groups that tend to support having larger producer groups in order to meet these larger orders from bigger retailers. And then some of it is there are, certain, beyond just labor costs, but certain technological approaches to maximizing the productivity of livestock, which tend to, sort of yield the greatest benefits when you scale them in one facility and do them a lot. Sort of information-driven approaches that require significant investment in the technology needed. But once the core technology is invested in, it's relatively inexpensive to add additional animals to the size. So those are the first ones that come to mind. I'm sure somebody who spends more time in the kind of agricultural resource economic space would have a more informed answer than I do.
Okay, that's very helpful. Thank you.
All right, Member Honker?
No questions.
Thank you. I don't know if we have member Bitzer or not. No. Okay. Is there any reason not to excuse Dr. Murphy at this time? Great. Thank you so much, Dr. Murphy, for your testimony.
Thank you. Happy to be here.
Let's see, now we go to a witness, Mr. Moody. Is that?
Madam Hearing Officer, I have an oral motion to make regarding Mr. Moody's testimony that I believe would be most appropriate before he and counsel begin. Madam Hearing Officer, the department moves to not allow admission to the record of certain portions of Mr. Moody's rebuttal testimony. You are entrusted by the board to, quote, make such orders as may be necessary to preserve decorum and to protect the orderly hearing process, end quote. The department's motion centers on the principle that providing false or intentionally misleading testimony is inconsistent with the decorum and ethical obligations binding all participants in this proceeding. I have 3 reasons to share. First, you must exclude those portions of Mr. Moody's testimony that purport to interpret New Mexico statutes or offer legal conclusions. He testified during direct testimony that he was not appearing here as an attorney. He is not authorized to practice law in New Mexico. And I'm sure if asked, he would say he is not at this hearing as an attorney representing AFPM. However, his testimony is replete with statutory interpretations and includes citing case law to support his points. This has flouted numerous orders you have provided in this proceeding during the direct portion of the case regarding the scope of legal testimony. AFPM is not prejudiced by this being stricken from his testimony and him not being allowed to testify to it today. It is appropriate commentary for counsel's closing statement. Second, Mr. Moody deliberately misrepresents information in his testimony, such as by applying selective language, including statutory texts and excerpts from the department's testimony in quotation marks as though accurately quoted. In reality, these passages are taken out of context and are altered to support AFPM's narrative. When the department fact-checked Mr. Moody's statements, it found them replete with distortions and selective interpretations, as well as being completely absent from the record or wrong descriptions of the language in the law. As a result, Mr. Moody's testimony does not allow for impartial consideration of the issues as required by the board's procedural rule. If admitted, it should be given no evidentiary weight and only be considered his point of view. The board's regulation at 20.1.401A states that all testimony is taken under oath. AFPM and Mr. Moody should have an opportunity to withdraw testimony that would cause the witness to violate that oath, both here and as an attorney. Lastly, Mr. Moody testifies to opinions regarding the steepness of reductions on a yearly basis being inappropriate. This is on page 7. He himself acknowledges these were requirements set by the New Mexico legislature. As you have already ordered regarding the 2018 baseline testimony from Dr. Schubert, such observations about what the statute, contrary to what the statute states, are not helpful to the board. Only relevant evidence can be admitted, and this is not relevant. Accordingly, the department respectfully requests that the hearing officer exercise her authority to exclude false representations of fact and law in Mr. Moody's rebuttal testimony, and that the testimony can only be offered by a lawyer to preserve the integrity of the record and orderly conduct of the proceeding. Thank you.
All right, thank you, Ms. Sona. Ms. Olson, would you like to respond?
Madam Hearing Officer, once again, unsurprisingly, I'm caught off guard with a 11th hour motion by the department. So I will respond briefly, recognizing that I haven't seen this motion. Mr. Moody's testimony was filed on the date rebuttal was due, and if the department wanted this to be seriously considered, I query why they didn't file a motion. Nevertheless, I'd like to remind you and the board why we're here. We're here for a rulemaking with the collective objective to examine whether the board has authority to adopt this rule, what the extent of that rule authority is, and the best pathway forward to get a workable rule that will accomplish the goal of the legislature. That should be the board's ultimate consideration here. The testimony by Mr. Moody is intended, as it states, to help inform the board of issues with the rule proposed by the department that the board can consider correcting in issuing a final rule. Mr. Moody has a legal degree He's trained in legal education, which means he's trained to analyze and question things. In his role as government relations and policy, he regularly reviews statutes and policies and identifies issues. He, as Ms. Sona correctly stated, is not appearing as counsel representing AFPM, but as an expert with a legal education. It's fully within the scope of his expertise to opine on legal defects within the proposed regulation. I'll also remind the board that by statute, the department shall be given the same status as every other party. They're not specially elevated here to be the gatekeepers of what can and can't be presented and what evidence should be given what weight. That's the function of the hearing officer and the board. These motions and presentations seem to just be for the function of trying to limit the scope of information that's available to you all to consider this rule. And I would urge you to take caution in the parties that are fighting very aggressively to keep information out of the record and look to the full scope of information before you to be sure that you can adopt the best rule for the state of New Mexico.
All right, thank you, Ms. Olson. I think what I'll do is accept the testimony with the caveat, obviously, that I see he has a law degree, a Juris Doctor, is not licensed in New Mexico, making observations about statutes, and in at least one case, case law. We will have a very brief window where the parties will be able to make written closing argument, and there's a lot of really great lawyering going on in this room. So I'm hopeful that the board will have the legal closing argument that they need to make their decisions. And of course, they'll be advised by Mr. Ugarte, and maybe to a lesser extent, I'll be pitching in too. But yeah, if he didn't have a law degree, I think I'd feel differently. But I see that he has one. It's not in New Mexico, and so I think it goes more to how heavily it weighs rather than whether it's admitted at all. So, anything else?
And Madam Hearing Officer, I just will add for the record, we wanted to flag it in testimony so the issue is preserved. I fully recognize that even if it wasn't preserved, the law is the law and it can be briefed by the lawyers.
Sure. Okay, so you're going to call Mr. Moody?
Yeah, I'm getting a lot of feedback. Are you guys, is it something I'm doing? Okay. So AFPM would like to call its rebuttal witness, Mr. Jeff Moody.
Is he on the platform?
He is.
I am.
All right. If you would spell your first and last name, please.
Yes, good afternoon. Jeff Moody. First name is Geoff. Last name is Moody, Moody.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Ms. Olson.
Thank you, Mr. Moody. Briefly, can you restate your current profession?
Yes, I am the Senior Vice President for Government Relations and Policy at the American Fuel and Petrochemical Manufacturers, AFPM.
And you previously provided direct testimony in this matter, correct?
Yes, I did.
And do you have before you what's been marked as AFPM Exhibit 4?
I do.
And do you recognize this as your rebuttal technical testimony pre-filed in this matter?
I do.
Was that testimony prepared by you or under your direct supervision?
It was.
And do you have any substantive changes to your rebuttal testimony?
I do not.
Is the testimony that you provided true and accurate to the best of your knowledge and belief?
To the best of my knowledge and belief, yes.
And if you were asked the same questions today under oath, would your responses be the same?
Yes.
And Madam Hearing Officer, I would ask that it be admitted. I think maybe you already accepted it.
All right, let me pause in the moment there are other objections.
Madam Hearing Officer,
Ms. Sona.
for the basis stated in our motion, we object.
All right, thank you. That's overruled. I'll admit it. Go ahead, Ms. Olson.
And Mr. Moody has prepared a brief demonstrative to support his summary of rebuttal. I do have hard copies if it would be helpful to provide to you all. And for time efficiency, I'll ask Mr. Moody to please proceed with his rebuttal testimony.
I'm going to share my screen here, and is my PowerPoint showing?
Yes.
Okay. Well, thank you for the opportunity to address the board today. I wanted to start maybe where we left off last time and just underscore why AFPM is appearing in front of you. It was alleged last time that we're not interested in seeing a rule, and there's some testimony around that. I just want to be clear that AFPM's goal here is a workable rule that allows obligated parties and others in the marketplace to understand what their obligations are going to be, and that there be clear, feasible, reasonable pathways to compliance for that. And our members have a lot of history with these types of programs, both in the United States and elsewhere, and can bring those to bear. So a workable rule is really our primary goal here. Number two, we want to see clear safety valves to protect New Mexico consumers. We think that's within the statutory ambit that the board was asked to look at. And so that's number two is we share the goal for emissions reductions without question, but it should not be at the expense of New Mexico consumers. And so finding that right balance. And number three, adherence to the statute. I am not here testifying in a capacity as a legal representative of AFPM or anybody. I'm not licensed in New Mexico. But in general, the association takes the position that these regulatory programs need to reflect the authority that they've been delegated by the legislature, and so adherence to the statute. So with those three goals in mind, just four things that we continue to identify as challenges, and we would request the board continue to take a hard look at. First, I would say broadly implementation challenges, and I'll get into each of these in a little bit more detail. Second, some additional clarity in the deferral authority section, and you'll see in my rebuttal testimony that we largely agree with the API NMOGA proposal on this, and so I think we can talk about that. Three, we think there is an impermissible technology bias embedded in this rule, and that includes the continued use of the EER, which we've already been talking about today a little bit. I'll talk about that a little bit more. And then fourth, we did identify a question around enforcement and the authority to adopt some of these enforcement issues. So I'll take each of these in turn. First thing on the implementation, first, it continues to be our strong recommendation that we have a reporting only period with no deficit accrual for a couple of years. This would allow additional market discovery, early credit generation, a build of a credit bank to provide liquidity into that market, and really ensure that the department has the time to get all the back end functions needed to run a program like this up and running. And so we make the point in the testimony that the statute requires a target by 2030. It does not require it doesn't specify what targets need to be accomplished in 26, 27, 28, 29. All it does is set a kind of a target in 2030. We do think that there's flexibility to allow for some additional implementation flexibility at the beginning of the program in order to ease implementation here. Second, the technology bias that I referenced, we identified a couple different ways this comes in. The EER, for all the reasons that we identified in the testimony, we believe should be removed altogether. It's a vehicle side credit, which we think should be not included in a fuels program. And we do not believe that it is within the scope of a life cycle analysis. Second, we note that electricity is defined as a transportation fuel, but at the same time, the only electricity that has a value associated with it at the outset of the program is renewable electricity assigned a carbon intensity of 0. There are, to the extent that this is supposed to regulate the carbon intensity of transportation, there's electricity being exempted out at the same time, liquid fuels are not. And so we think there's a contradiction there. And then 3, there's some assumptions within the modeling on the extent of the electrified mass transit that we think could be updated. On the enforcement authority, we just note that the department hasn't identified the statutory authority for the asserted authority in the proposal, and we just ask that the department take a hard look at that, and we'll be ready to brief that in our closing statements. And then finally, the deferral authority. We view these things as the deferral authority as an important consumer protection mechanism at the end of the day, and so there are 2 levels of this. There's the emergency, which we believe should be flexible enough to allow the department to deploy it quickly, if an emergency arises. And then, as I mentioned, establishing some clear thresholds for forecasted deferrals related to credit availability. Automatic triggers are appropriate, and we believe the API NMOGA proposal is a workable way to do that. That should be tied, we think, to independent third-party calculations to ensure we're not getting bias in that process, and that we're really protecting New Mexico consumers there. And then finally, related to that, we think that the transportation fuel cost should be within the scope of public interest for an emergency and frankly, forecasted deferrals. These are these programs have cost, policymakers should have tools available to them to mitigate those costs if they see fit. So those are my 4 brief points. I'm happy to talk about any of those in more detail, but those are the summary of what's in my testimony.
Thank you, Mr. Moody. That concludes our presentation of rebuttal testimony. Tender him for questioning from the board and cross-examination by other parties.
Thank you, Ms. Olson. Mr. Noyes, do you have questions of Mr. Moody?
Thank you, Madam Hearing Officer. No questions.
All right. I don't think we have Mr. Nasco or Mr. Duff. Mr. Smith, do you have questions of Mr. Moody? You have stepped away. Mr. DeSalen or Ms. Gerson?
No questions, Madam Hearing Officer. Thank you.
Thank you. He said no questions. Mr. Lobdell? He may have stepped away. Mr. Sorayas?
No questions. Thank you, Madam Hearing Officer.
Thank you. Ms. Veracruz? She said no questions. I don't think we have Ms. Tremblay with us. Mr. Maxwell, do you have questions?
No questions.
Thank you. Mr. Weatherby?
Sir.
Okay. Mr. Harris?
No questions, Madam Hearing Officer.
All right. He said no questions. Mr. Tucker? No questions. Ms. Nope, Ms. Olson's already gone. Mr. Molenberg?
No questions.
Mr. Trujillo, thank you. And Ms. Sona? Oh, Mr. Smith has questions. All right. Go ahead, Mr. Smith. Does not have questions. Ms. Sona?
Thank you, Madam Hearing Officer. Good afternoon, Mr. Moody. You can see the back of my head, but I can see your face. My name is Kelsey Sona. I am counsel for NMED. I know last time you were questioned by Ms. Nixon. You get me today. I wanted to start off with clarification that you are not testifying today as an attorney, correct?
That's correct.
And are you aware of the consequences for the practice of unauthorized law in New Mexico?
Madam Hearing Officer, I'm going to object as badgering the witness.
Ms. Sona, I understand you have a point that you want to make, but I'm hoping you have questions that go to his testimony.
Madam Hearing Officer, I do. This actually goes to a statement that he made during his oral. That is going to be my second question after he answers this.
All right, go ahead.
Mr. Moody, do you need me to repeat the question?
I am not specifically familiar with New Mexico's rules now.
Okay. During your oral summary, you stated, quote, "We will be ready to brief," end quote, regarding issues. What did you mean by that in terms of the we?
AFPM in coordination with our council that we're represented by. So I was responding to your statements earlier that we would have opportunity after the hearing to make legal arguments.
And when you testified that your testimony was prepared by you or under your direct supervision, did that include through counsel?
Madam Hearing Officer, I'm going to object as attorney-client privilege.
Yeah, I'm not sure this is helpful in any event, Ms. Sona.
Mr. Moody, your testimony alleges that the department cut and pasted this rule from the other clean fuel programs. Do you recall that portion of your testimony?
I do.
Do you recall Mr. Vaughn's testimony that the department has spent over 13,000 staff hours and over 18 months developing the program, including over 63 meetings between the department and other program administrators?
I did not watch Mr. Vaughn's testimony, no.
Did you watch any of the testimony provided by the department witnesses?
During which phase? The direct phase?
Yes.
Some, not all.
Do you recall which witnesses you watched testimony for?
I do not.
Would you have any reason to doubt the information that I just shared with you regarding Mr. Vaughn's testimony?
No, I don't.
Okay. Given all of that work that went into preparation for the rule, is it still your position that you want this board to believe that the department just cut and pasted another state's rule without informed thought?
I don't want to leave the impression that, look, I know a lot of work goes into these things. These are the point we were trying to make in the testimony was that New Mexico is a unique fuels market, has unique challenges, and it's a unique statute that isn't necessarily reflective of even authorities given in other states. So, you know, the point we were trying to make is take the time, try to understand the unique aspects of New Mexico, and provide the market time to adjust. And really, everything here is coming back to this phased implementation that we're talking about in the rule, because we think that's going to lead
Mr. Moody, I understand
we're going to lead to
shifting.
the most. That's going to lead to a successful program, and that's really what we're trying to. Back to my original point, that's what we're trying to do here. So I don't want to. I don't mean to diminish the work of the work.
One at a time.
Sorry, I believe there's a delay between us and the platform, so I apologize, Mr. Moody, if I'm seeming to cut you off.
Madam Hearing Officer, I would ask that if she is questioning the statements in his testimony, she gives him a full opportunity to answer the question.
Thank you, Ms. Olson. Go ahead, Ms. Sona.
So what I heard in your answer to that question, Mr. Moody, was that you are clarifying that you are not testifying that the department cut and pasted the rule. Is that right?
We took some creative license in the written rebuttal. It was not to imply that. I think it was clear from the written statement that it was not intended to mean strictly, yes, this is cut and pasted. The idea was this is a unique market with unique circumstances, you know, and it deserves continuing attention. So that was the point, and it was not to diminish the work of the department or others.
Your testimony on page 7 takes Bureau Chief Borchardt's explanation of a general climate policy categories and selectively quotes it to be as if she described the CTFP itself as a transportation reduction strategy. That characterization does not accurately reflect what her testimony was, correct?
I don't know that that's correct. I would have to go back and reread her testimony. I don't specifically recall that part of the exhibit at this point.
Okay, let me read it to you and we'll circle back to that question. So at the bottom of page 4 of the department's exhibit 63, which is where you take your quotes from, what Ms. Borchardt stated was, quote, generally, transportation reduction strategies fall into 3 policy categories: introducing cleaner and more efficient cars and trucks on the road, comma, reducing emissions from the fuel powering the fleet on New Mexico roads, comma, and or reducing the miles each vehicle travels, because most policies that address any one of these policy categories are complex to implement. The transportation sector is often considered, quote, hard to abate, end quote. As its name suggests, the CTFP addresses the fuel component of the climate transportation three-legged policy stool. Also,
Okay.
for your reference, on page 7 of your testimony, you stated AFPM is concerned that the chief of the Climate Change Bureau has testified that CTFP is essentially a, quote, transportation reduction strategy, quote, that includes, quote, reducing the miles each vehicle travels, end quote. So let me ask again. Bureau Chief Borchert did not testify that the program is intended to reduce vehicle miles traveled, correct?
Again, not in that passage. I'm trying to, reading this and trying to interpret what you're saying here. In that passage, no, I don't think that's what she said. But I think what she's saying, what I heard you say, and again, I don't have it in front of me, so I'm reacting, to, on a multi-sentence thing. That reducing emissions in the transportation sector is multifaceted, and so I, without having it in front of me, honestly, I'd have to go back and take a look at this again.
Was this a portion of your testimony prepared by you or prepared by others?
Madam,
This part.
He's already answered. The testimony was prepared by him or under his supervision. The question's been asked and answered.
Well, no, she's asking about this particular paragraph. Go ahead, Mr. Moody.
I did not write this particular sentence, so I would need to go back and look at that.
Thank you. Turning to another portion of your testimony, but also on page 7, you advocate for a, quote, effective date after July 1, 2026, end quote. Is that a correct quote of your testimony? Or is that a correct understanding you have of your testimony?
I think what I'm reading the passage. I have it open in front of me. My point, the point here is that there's a July 1 deadline for the board to adopt rules, but the accrual of deficits and the annual emissions targets are not specified in the statute, and so the board has the ability to delay the effective date of deficits, for instance, until a later time. I think that's the point we're trying to make here.
Mr. Mooney, I understand that maybe you have a different perspective of what I'm reading and the point, but if you could listen to the questions I'm asking, there's sometimes asking something a little bit different, and it would help us if you could listen and answer directly to them, please.
Madam Hearing Officer, he answered the question.
Yeah, I thought he did after he was able to read it. I thought he was doing his best to answer the question. Ms. Sona, you've got about 3 more minutes.
So, Madam Hearing Officer, most of my cross-examination questions are working to address the misconceptions, the false statements that are provided in Mr. Moody's testimony, and you allowed this testimony to proceed despite the objections the department had. The board's rules explicitly state that the purpose of cross-examination is for a full and truthful matter and exploration. I'm entitled to cross-examine him without the arbitrary constraints of time on whether or not there's falsehoods in the testimony, and this is what I'm trying to get to. Mr. Moody is going off on tangents in his testimony. He's not listening to the direct questions. I am trying to be polite and specific and give him guideposts that I'm quoting directly, and he is instead testifying instead of answering my questions. So, this, I'm not gonna, I'm objecting to the time constraint of 15 minutes.
And Madam Hearing Officer, I just respond very quickly. It's shocking to me that the department feels it doesn't have to abide by the rules that it has set for every other party in this case. Ms. Sona had the direct testimony. She had the scope, or the rebuttal testimony. She had that scope of testimony in front of her, and she has not sought concurrence of counsel or special permission to be afforded extra cross-examination for concerns she has about his testimony.
All right, so it is a little bit after 2:30. You had about 3 minutes left, but there were a couple of objections, so let's call that 5 minutes. Let's take a 15-minute break. Ms. Sona, if you would prioritize your questions, you can pick up with 5 minutes when we come back. Thank you. Let's take 15 minutes and come back at 10 of 3. Sorry, Ms. Sona, let's see. I would like you to spend 5 minutes with your highest priority questions of the witness.
Thank you, Madam Hearing Officer. I actually have no more questions for Mr. Moody.
All right. Thank you very much. Let us go then back to Ms. Olson.
Madam Hearing Officer, I do just have very brief redirect, if you don't mind if I just stay put where I am. Mr. Moody, you're currently the Vice President of Government and Relations and Policy for AFPM, correct?
Senior Vice President, yes.
Senior Vice President. And how many members are there of AFPM, approximately?
You mean member companies?
Yeah, sorry, member companies and others, I guess.
Yeah, I mean, we have several hundred member companies, but in terms of kind of our refining membership and operating company membership, I think it's something like 60. I'd have to go look at exactly.
And as you were preparing your testimony for this proceeding, did you consult with the membership of AFPM?
Of course.
And did you elicit feedback from them on your rebuttal testimony?
Objection, Madam Hearing Officer. Counsel objected to my questions regarding who Mr. Moody had consulted with in preparing his testimony, and so I do not believe this is appropriate for redirect.
Okay, no, I think that's okay. We've had a fair amount of testimony like that in these hearings. The executive directors of professional organizations consulting with their members. Go ahead, Ms. Olson.
I apologize. I got distracted by the interruption. I think I was asking you if you elicited feedback from your member organizations specifically in developing your rebuttal.
Yeah, my members had a chance to review our testimony.
And did you strive to incorporate the comments you received from members into your testimony?
Where we could, yes.
And I want to turn to page 7 of your testimony, the last paragraph that counsel questioned you on.
Okay.
Was the purpose of these statements in your testimony to restate verbatim department witness testimony?
No, we were trying to make a broader point, and maybe it should have been more artful. I can certainly concede that, but the point we're trying to make is New Mexico has a statute that's unique to New Mexico, has a market that's unique to New Mexico, and we hope that the board walks into promulgating the final regulations to leave flexibility to reflect those circumstances. That's all. So we, that's all we were trying to say with this part of the statement.
And is that true throughout your testimony for other statements attributed to the department?
Yes.
Thank you, Madam Hearing Officer. I have no further questions.
Thank you, Ms. Olson. Member Ely, do you have questions of Mr. Moody?
Yes. Hello, Mr. Moody.
Hello.
So you stated in your demonstrative exhibit and a little bit on page 13 of your rebuttal that the legislature did not authorize administrative compliance order or assessment of civil penalties. And then are you simply looking at the 74-1-18, the act or the statute we've been referring to throughout this hearing as the Clean Transportation Fuel Standard? Or go ahead, please. I'm sorry.
Yeah, I mean, yes. So I know, I had a chance to look at both that and then the Environment Improvement Act, and I know we were cross-referencing the two and noted a potential, just a question, and we raised it as a question and an area for potential clarification. That's all. But yes, I mean the combination between those two, we noticed that there was enumerated enforcement authorities for administrative compliance and civil penalties, and with specific circumstances that where the legislature had given the department that authority, and then we did not see that in the amendments to the implementing the Clean Fuel Transportation Standard.
Yeah. Okay. I was just making sure you're looking at the broader general provisions of the Environmental Improvement Act, and it sounds like you have.
Yes.
Right. Thank you. That's all.
Thank you. Madam Chair?
No questions at this time.
Thank you. Member Garcia?
No questions. Thank you.
Member Honker?
No questions. Thank you.
All right. Thank you. Any reason not to excuse Mr. Moody? Terrific. Thank you, Mr. Moody.
Thank you.
It seems like we need to talk about our upcoming witnesses here. I would call on NMOGA in the event you had other rebuttal.
Madam Hearing Officer, from the discussion this morning, I understood that we probably received the Oxy and
Can I hear Mr. Mulberg?
Thank you, Madam Hearing Officer. Just asking about the order of testimony. We have our two rebuttal witnesses available on the platform at some point. I don't know if they're available at this moment. I was thinking from the order that you discussed this morning, we'd probably go to Oxy and HF Sinclair before NMOGA API. We can be flexible, but if we're going to go to us, just want to make sure we're ready to go. While you're looking at that, another point that we want to or need to discuss to some degree procedurally is we do have a motion that we filed this morning to allow some short surrebuttal. So whenever it meets your pleasure, we can have that discussion.
All right. Thank you, Mr. Mullenberg, for reminding me that I had yet a different list. List for presentation, list for reverse presentation, list for cross-exam, list for reverse cross-exam. I need to be finding the right list. Sorry. Oh, you're right. So I had American Fuel, but it seems as though they have already put on the one rebuttal witness they were going to put on. And then you're right, it is Oxy. And Maxwell, Sinclair, and then Nemova. Thank you very much for that. Let me ask, though, I did take a quick peek at your motion to put on Sir rebuttal, and it looked like Sir rebuttal to me insofar as you were careful to identify the rebuttal testimony you would be rebutting. Do folks want to talk about this tomorrow? I know it was filed today. Do you know whether you have an objection today?
So, Madam Hearing Officer, as far as I know, there isn't any objection to allowing the Sir rebuttal, but there were some comments when we were conferring with other counsel about the timing and manner in which the Sir rebuttal would be presented. Again, I think we're flexible. And again, counsel can correct me if I'm not representing things correctly. I believe the department's view was that we should present the Sir rebuttal before the department begins its rebuttal testimony. A couple of other parties had suggested that maybe Sir rebuttal should be done orally after all the rebuttal was in. And we don't necessarily have a position. We are prepared to file the Sir rebuttal testimony as written testimony, and then put the witness on for a brief summary and cross-examination. And the witness is Dr. Schubert, who is not presenting rebuttal testimony. He would come on only for the proposed Sir rebuttal testimony. So I think I've covered.
And it looks as though people were generally agreed that the appropriate amount of time would be 15 minutes.
Yeah, I think, and I think it's certainly short enough. The summary can be done in 15 minutes or fewer, and then obviously there would be, I presume, an opportunity for questioning of the witness on the Sir rebuttal.
Yeah, and Ms. Sona, I understand completely why you would want to still have the last word, if you would, as the petitioner.
Thank you, Madam Hearing Officer. The only piece of information I would add to Mr. Mullenberg's summary, which did accurately capture our conversations, was that I'd also asked to have at least an evening to review his Sir rebuttal testimony so that our witnesses have time to look at it. We can adequately prepare cross-examination. So I do believe an order today with an instruction to file by 6 p.m. maybe would be most appropriate to allow that to occur.
All right, thank you. That sounds reasonable. Mr. DeSalen.
Thank you, Madam Hearing Examiner, Madam Hearing Officer. I've been bouncing around in hearings lately. We also, on behalf of Coalition for Clean Affordable Energy, we also want to put on some rebuttal testimony, very short. We were planning on trying to do it orally, but we're flexible. I mean, we could present some written testimony. We were also thinking that maybe the easiest way to do it would be to put our rebuttal testimony on immediately after, our Sir rebuttal testimony on immediately after our rebuttal testimony, just because I think it would be more convenient that way. And that would, I think, satisfy Ms. Sona's suggestion that the Environment Department do its witnesses last.
All right, thank you. I think that makes sense, especially because cross-exam then can be one go. Ms. Sona.
Madam Hearing Officer, this is the first that I'm hearing that CCAE is requesting to present Sir rebuttal. I'd request that we be given an opportunity to hear topically what that is on and what it is addressing, as well as the opportunity to review it in advance. Now being asked to review 2 Sir rebuttals, I think we're getting close to problematic of having to prepare cross-examination for tomorrow. And it pushes us further into a problematic timing situation, you know, we haven't seen the SIR rebuttal, and so I can't agree, you know, that we're not going to object to it.
All right, thank you so much. Certainly, I wouldn't ask you to waive your right to object. So those two gentlemen there, if you would please get your SIR rebuttal shared in writing with the other parties, and they can take a look at it, and then we'll find the best time to do it. And I like your idea of doing it after your rebuttal. I like the idea of limiting it to 15 minutes. Mr. Mullenberg.
Yes, thank you, Madam Hearing Officer. I was just checking on the status of the written SIR rebuttal. Apparently, we're still working through some comments and editing. I don't know if we'll have it done by 6 o'clock this evening as requested by Ms. Sona, but we will proceed with that as rapidly as we can and get it filed, get the written testimony filed to provide an opportunity for review and preparation for cross-examination. Thank you.
All right, thank you so much. Same, Mr. DeSalen? Okay, thank you. All righty. So let me go back to my list. Oxy. There you are, Mr. Tucker.
Ms. Jones, can I get permission to share?
And is this Mr. Gray?
This is Mr. Yes.
Okay.
This is Mr. Gray.
All right, thank you. Again, just for the transcript, would you spell your first and last name, please?
Absolutely. My first name is Shannon, Shannon. Last name Gray with an A, Gray.
And I think I swore you in earlier, so you're good. Mr. Tucker.
Good afternoon, Board Chair, Commissioners, Madam Hearing Officer. Oxy calls its first and only rebuttal witness, Mr. Shannon Gray. Mr. Gray, thank you for being here. Could you please state your name and role for the record?
Yes, my name is Shannon Gray. I'm a product development engineer for 1.5, which is a carbon capture and storage company, subsidiary of Oxy USA Incorporated, based in Houston, Texas.
Thank you. And you previously provided direct testimony in this hearing?
That is correct.
And your qualifications and experience were provided in your direct testimony as well as in the resume admitted as Oxy USA Exhibit 5.
That's correct.
Okay. Is Exhibit 9 a copy of your rebuttal testimony?
Yes, it is.
Do you have any changes or corrections to make to your rebuttal testimony?
I do not.
Okay. Do you adopt your rebuttal testimony in its entirety today?
I do.
Okay. Thank you. Could you please provide us a summary of your rebuttal testimony?
And please keep it slow.
I will, and I will do my best. So the purpose of my rebuttal testimony today is to respond to the direct testimony of certain parties to this proceeding. More specifically, I will address an alternative fuel pathway for direct air capture and enhanced oil recovery, book and claim accounting, and project crediting. The NMED's draft rule would require fossil fuels to utilize fuel pathways and carbon intensities listed in the lookup table in section 20.2.92.701D of the current draft rule and would prohibit potentially lower carbon intensity fossil fuels from applying for an alternative fuel pathway. NMED Exhibit 67 at 13-14. In support of MNED's position, Dr. Rosso testified that, quote, due to the interconnected nature of fossil fuel gathering, refining, and distribution, and limited public data availability for individual fuel stream life cycles, there is no viable way to determine and verify exact production, transportation, and storage emissions for individual fuel streams. End quote. NMED Exhibit 67 at line 15. In my experience, the carbon intensity of a fossil fuel system can indeed be certified to a similar degree of a non-fossil fuel-based systems, given that the underlying data can be provided and verified by a qualified third party. Dr. Rosso's statement is based on the premise that the underlying fuel system data is not available. This is incorrect. The underlying fuel system data can be collected by an operating company and offered as evidence to support an alternative fuel pathway. The values in the lookup tables are the result of applying well understood life cycle analyses to a particular category of fossil fuels. Limiting fossil fuels to solely utilizing the lookup table in 20.2.92.701D forecloses the development of innovative fuels with a lower carbon intensity, such as fuel produced from a direct air capture to enhanced oil recovery or DACT EOR project and other innovative methods. To determine how a DACT EOR pathway might be verified under the Clean Transportation Fuel Program, I have prepared an outline summarizing the lifecycle steps in the chain of custody with monitoring and verification procedures at each step. I'd like to call the attention to the slides, which my attorney is currently presenting. What you'll see on the slides here is a graphic that shows a simple life cycle diagram of the process that we have been describing and proposing in this hearing. From left to right, you have the direct air capture process, which captures CO2 from the atmosphere and brings that CO2 into a shared commingled network, which currently exists and is deployed throughout the southwestern United States. You then have the enhanced oil recovery process, which does two things. It sequesters that CO2 and it produces hydrocarbons, which fuel transportation. You then produce those hydrocarbons into another commingled and shared infrastructure system. Those volumes of hydrocarbons are sent to a refinery where they are refined into a blend of refined products. The example that we show in the graphic shows jet fuel, but it could be easily gasoline or diesel or any other transportation fuel commonly used on the road in New Mexico. We've prepared a significant write-up, what I think is fairly significant of what this could look like. We're not going to go into all the detail to save time today, but we would like to touch on the finer points of an outline of how we think this could be done to provide a usable example and reference to the board. So going from left to right, starting back at the direct air capture process, we've simply highlighted what we think are the ins and outs of the process to allow a very simple chain of custody for the environmental attributes and the fuels that are created from this process. So here in step one, we have the direct air capture process. The custody at this point in time would be the direct air capture operator. In this case, it would be Oxy. The DAC process takes low carbon power. It can take low carbon natural gas or natural gas from a pipeline. It takes non-potable water, commodity chemicals, and then of course air. From that, it produces a condensed stream of CO2. All of those inputs can be tracked and measured with existing industry standard methods and metering devices. We have invoices and tracking for all of those. That's how we track our cost. And the output of that is a simple distilled stream of carbon dioxide, which would be put into a shared network in the United States. Those volumes are tracked and traded through our agreements with those companies. And we have mass of those systems, which we use to pay for those systems today. Moving on, we then entered the CO2 EOR pipeline systems in the United States. Again, for reference, this is one of the largest CO2 systems on the planet. There are literally thousands of miles of pipeline connecting the states of New Mexico, Texas, Oklahoma. They're currently looking at pilots up in the Colorado Rockies where they're exploring CO2 EOR, and we're bringing CO2 from Colorado into these systems. These systems are operated every day. You put in the mass of these systems, you trade those volumes on the pipeline, you monitor the pressure, the temperature. We have operational systems at our operational facilities, and we even have control and command centers monitored by the Department of Transport in various locations throughout the Southwest United States to make sure these lines are operating in compliance with the DOT. But pipeline systems are very simple. You put in CO2 and you take out CO2. So you trade those volumes, you meter those volumes with technology and meters that have been around for 30 to 40 years. They're highly accurate, they're verified. We can attest to the safety and the integrity of these systems in the United States. Next slide. We then move to the CO2 EOR pathway. This is the loop in the first diagram. So here you have the simultaneous injection of CO2. That CO2 is dissolved into the oil phase, which is in the pore spaces of the rock. It swells the oil, it makes it less viscous, it causes that oil to flow out of the rock, be produced, and as a byproduct of that process, the CO2 that was used as the miscible solvent is left behind in the rock. And over a certain amount of cycles, that CO2 is permanently geologically sequestered. We track and report that amount of CO2 to the US EPA through their various EPA MRV programs. Oxy has, I think, 4 of these programs today. We're working on a 5th. The inputs and outputs of these are very much based on the emissions reporting and emissions inventories in these states. So you're going to see various parts of the greenhouse gas reporting rule. I believe we've looked at subpart R in the rule.
I'm sorry, sir. Sorry, sir. You're going to see various parts of that. Slow down just a bit.
No worries. You're going to see various parts of the federal regulations, which Oxy did mention in its initial testimony for these reporting programs, which are used to report the volumes to the EPA and the IRS to claim federal tax credits under the 45Q tax crediting program. The outlets of these systems are lower carbon hydrocarbons, which are then sent to our existing distribution and collection systems. Those volumes are traded and commingled in a shared common infrastructure. They can be bought and sold at traders or by traders on these pipeline networks, and then refined into lower carbon products at a given refinery. The refinery is going to have inputs and outputs just like any other process, which would need to be included under these programs. That includes my example for the slides. I'll continue with my written testimony. So in summary, fossil fuels such as those produced from DAC to EOR can be accurately verified and tracked. Although the verification process described above for fossil fuel applications
You're speeding up.
requires more steps and time than the use of lookup tables. Applications that meet all relevant requirements are consistent with the objectives of the CFTP and should be permitted to proceed through the alternative fuel pathway process. For this reason, the board should adopt a final rule that allows any fuel produced using innovative methods, such as DAC to EOR, to apply for an alternative fuel pathway. I'll now move on to discuss book and claim accounting. The Coalition for Clean Affordable Energy recommends that New Mexico's Clean Transportation Fuel Program prohibit book and claim and mass balance accounting. CCAE Exhibit 9, lines 36 to 48. CCAE also claims that liquid transportation fuels present special risks for book and claim accounting. CCAE Exhibit 9 at line 45. On October 24th, 2025, NMED shared a revised draft of its proposed regulatory text. Although MMED's October 24th draft retained book and claim and mass balance accounting, NMED revised its proposed text to disallow liquid transportation fuels from utilizing book and claim. Oxy supports the use of book and claim accounting as well as mass balance accounting in New Mexico's Clean Transportation Fuels Program. Book and claim accounting is utilized by all other clean transportation fuels programs and is widely recognized as an effective and efficient accounting method for generating carbon credits. International standards for book and claim accounting have already been developed and are currently in use. Prohibiting book and claim accounting would make New Mexico's program an outlier and imperil the ability of participants in the program to generate credits. Similarly, mass balance accounting is a practical, efficient, and systematic method for tracking the flow of fuels through production, processing, and distribution systems, particularly for reporting in commingled transactions. International standards have also been developed for mass balance accounting. Oxy opposes disallowing liquid transportation fuels from utilizing book and claim accounting and recommends that the board retain the original draft language. Liquid transportation fuels are routinely tracked and verified in the same manner as
Sorry,
gaseous
sir.
transportation.
Slow down again, please. Oxy opposes disallowing liquid transportation.
Let me back up. Oxy opposes disallowing liquid transportation fuels from utilizing book and claim accounting and recommends that the board retain the original draft language. Liquid transportation fuels are routinely tracked and verified in the same manner as gaseous transportation fuels. Therefore, excluding only liquid transportation fuels is arbitrary and unnecessarily limits their ability to utilize alternative fuel pathways. Making liquid transportation fuel ineligible for book and claim accounting would disincentivize the development of low carbon fuels in New Mexico. The cheapest and most widely used way to get low carbon fuels to New Mexico is through common carriers. In order to properly account for the environmental attributes and benefits of fuels commingled in a common carrier, the party must utilize book and claim accounting of some kind. Removing liquid transportation fuels from book and claim accounting also violates the requirements that the program establish a technology neutral mechanism. I'll now move on to project crediting. Parties in their direct testimony and during the hearing voiced concern about a lack of details in the proposed project credit provision in 20.2.92.306. In response to comments and concerns, NMED provided parties to the rulemaking hearing a revised draft of its proposed regulatory text on October 24th, 2025. NMED's October 24th draft made substantial changes to the project crediting provisions in Section 306, including details regarding eligibility, applications, application review, credit generation, as well as record keeping and reporting. Oxy is generally supportive of NMED's revisions to 20.2.92.306. In particular, Oxy strongly supports NMED's listing of direct air capture and point source capture with permanent storage as types of projects eligible for project crediting. NMED adding eligible product types to the rules provides regulatory certainty to applicants and helps the rule fulfill the statutory objective of providing additional credit opportunities from activities and projects that support the reduction of greenhouse gas emissions associated with transportation in the state. Oxy supports NMED's efforts to develop the application review process for project crediting and offers several changes that it believes will improve the rule. First, Oxy proposes that the department should be allowed to consider approved protocols for similar projects developed by accredited voluntary carbon standards. Second, reasonable deadlines are necessary to ensure project applications are processed in a timely manner. Third, the rule should adopt a clear standard for when greenhouse gas reductions from project credits are deemed voluntary and additional. Oxy recommends that the department be allowed to consider approved protocols for similar projects developed by accredited voluntary carbon markets. Voluntary carbon markets have already developed standards and protocols for a variety of project types to facilitate the generation of carbon credits. To ensure that these protocols and standards utilize best practices and are producing verifiable credits, organizations such as the International Carbon Reduction and Offset Alliance, or ICROA, have developed certifications. To help facilitate the development of its own protocols, NMED should be allowed to consider existing protocols developed by accredited voluntary carbon standards. Reasonable timelines are necessary to ensure project applications are processed in a timely manner. New Mexico's Clean Fuel Transportation Program sets an aggressive short-term reduction goal for 2030. To accomplish that goal, a sufficient number of credits, including from project credits, will be needed to be generated, particularly in the first few years of the program. Oxy recommends the incorporation of reasonable deadlines consistent with the timeline set forth in MEDD's air construction requirements in 20.2.72.207. Oxy recommends revisions to the credit generation provision. Oxy agrees that project credits should only be issued for reductions and removal projects that are voluntary and additional. NMED's draft language is vague and imprecise at times. Oxy has proposed revised language to clarify and simplify when greenhouse gas reductions from project credits are voluntary and additional. In conclusion, Oxy's recommended changes to the revised draft rule are included in our exhibits, Oxy USA Exhibit A. Oxy's red line to MNED's revised draft proposal includes an alternative fuel pathway for DAC EOR, retains book and claim eligibility for liquid transportation fuels. And in addition, Oxy is proposing minor revisions to the project crediting section to address potential protocols for project credits, the timeline for the NMED to process applications, and revisions to the definition of when the project credit reductions are considered voluntary and additional. This concludes my rebuttal testimony. I'd like to thank you for your time and attention.
Thank you, Mr. Gray.
Thank you. I'd like to move at this time to admit Oxy Exhibits 8 and 9.
We'll pause for a moment in the event there are objections.
Madam Hearing Officer?
Ms. Sona.
Not a specific objection for Exhibit 8, but I would like the record to reflect that it's based on an exhibit being testified about that's not admitted into the record yet, which is NMED Exhibit 121, the discussion draft rule.
All righty, but we believe we're going to have that in. All right, great.
I'll now pass the witness. Thank you.
Thank you very much. So they're admitted, and let us start with Mr. Noyes. Mr. Noyes, do you have questions of Mr. Gray? He may have stepped away. I don't see Mr. Nasco, Mr. Duff, Mr. Smith. Nope. Mr. DeSalen.
No questions, Madam Hearing Officer.
Thank you. He said no questions. Mr. Lobdell. Mr. Sorayas. Ms. Veracruz. No questions. She said no questions. I don't think we have Ms. Tremblay with us. Mr. Maxwell.
Hello, no questions. Thank you.
Thank you. Mr. Weatherby. Okay, Mr. Harris.
Question, Madam Hearing Officer.
Thank you. He said no questions. Let's see. Ms. Olson.
No questions, Madam Hearing Officer.
All right. She said no questions. Ms. Sona. I'm sorry, did I skip? I skipped Mr. Molenberg.
No questions.
No questions. All right. Now, Ms. Sona.
Thank you. Welcome back, Mr. Gray. You and I met before. My name is Kelsey Sona. I represent the Environment Department. I want to start off with a question that, at a high level, do you agree with me that the one purpose of project credits is to support innovative activities that the rule would not otherwise cover?
I think that is correct.
And do you agree that NMED has explicitly provided a mechanism through project credits for DAC-related activities, correct?
I think they've listed it in the credit section of the rule.
Thank you. Your written testimony includes a 5-step chain of custody life cycle diagram for DAC to EOR verification, correct?
That is correct.
Madam Hearing Officer, would you let me know when I have 2 minutes left? I didn't bring my phone up.
I will.
Thank you. Mr. Gray, are you aware that the department asked for this information multiple times to be able to fully evaluate Oxy's request for a pathway, and that Oxy never provided this information?
No, I was not aware of that.
So is it fair to say then that the first time the department saw this methodology, if what I'm representing to you is true, would have been when the rebuttal testimony was filed?
I can't speak to when MNED would have seen some of our projects, but I can say that the project that we're implementing, Project Stratos in West Texas, is publicly listed on VERA's voluntary carbon registry. There's a lot of public information available.
Are you familiar with Table 4 in NMED's rule?
I am not intimately familiar with all the tables, but I can pull it up if you give me a moment.
It's going to be a high-level question, so.
Okay.
All right. It's going to be at the very end of the rule.
Is this just the lookup table?
This is the lookup table.
Okay. I have the table.
Okay. The numbers in Table 4 of the rule represent a modeled average fossil fuel supply chain for New Mexico, not any particular batch or source, right?
I believe that is correct.
And this is because, setting aside your position regarding DAC to EOR, the interconnected nature of the system and limited data make it infeasible to assign unique life cycle emissions to most fossil fuel streams, correct?
So I believe that is correct. I believe that's also one of the reasons that the University of Stanford, California at the time, Argonne National Labs worked together to develop the OPGEE model. So the oil and gas production greenhouse gas estimation model. It was a model that was basically designed to predict emissions for oil and gas fields that didn't have the available public data. It was used, I believe, domestically, and I think California models it to uses it to model crudes internationally as well. But the distinction, I think, between these models, and I think the point that you're trying to make is, when you have the data, the need for those models changes. When you have the data, the need for that model is really more of a check to make sure that what you're presenting is in line with reality, with the physics, with the production science. And so I believe that answers your question, but let me know if I haven't.
That does, thank you. I'm going to get to some more questions about that too.
Okay.
It's correct that no other low carbon fuel program allows liquid book and claim, right?
I believe with the one exception of Oregon for sustainable aviation fuels, Washington and Boeing has a lot of pull there, so I think they made that exception. Then I think book and claim accounting is also allowed in the international programs for aviation. So the Corsia programs under ICAO, I believe it's also allowed there. It's also a place where I think book and claim accounting makes a lot of sense, where you literally have planes flying between countries and over oceans, and it's hard to get fuel from one to the other.
And no other low carbon fuel program allows fossil-based alternative fuel pathways, correct?
I don't believe that's correct. I believe the California program has a few provisions where they allow innovative crude provisions, such as putting wind or solar or other renewable sources behind the meter to power some of their operations. If you had, say, some steam floods in California, and you were producing, say, that steam through a natural gas or a coal-fired boiler, if you captured that CO2 and then sequestered it, I believe you get credit for that, which would be on the fuel.
So I anticipated you would say California. And
yes,
it's correct that California uses the term pathways to describe what in the New Mexico program would be more the equivalent of what we are looking at for project credits. So to say there is an alternative fuel pathway, the way that the New Mexico program is presenting it, that's not comparing the California innovative project credit pathways isn't an apples to apples comparison, right?
I would disagree. I think California actually uses the term pathway to refer to either a fuel pathway or a project crediting pathway. And I think there's a lot of similarities, I think, that we're proposing here in the rule. The other thing that California does, which we as Oxy have always taken issue with, is they made the choice for industry on which pathway to choose. So in California, they explicitly prohibit projects such as direct air capture to enhance thermal recovery. And we believe they prohibit that because they don't want the impression that they're somehow incentivizing additional oil and gas production, even if that oil and gas production is lower carbon when you do the life cycle analysis.
What you're asking here is for New Mexico to go above and beyond what California has acknowledged and to do what no other jurisdiction has done in allowing both an alternative fuel pathway for all fossil fuel, not just innovative fossil fuel, and to allow project credits, correct?
I'd have to check our red line, but I believe we're applying for innovative fossil fuels here.
Would it surprise you if the red line doesn't say that?
I think it would.
Okay. There's reasons why these other jurisdictions have resisted lobbying for fossil-based alternative fuel pathways, right? And you can just say yes or no.
I'm assuming they have reasons, yes.
Okay. For one of those reasons, alternative fuel pathways for fossil fuels would require refiners and distributors to disclose proprietary production, blending, and transportation information to avoid double counting, right?
I believe that's true. I believe a lot of those refineries already disclose a lot of that information to organizations such as the Energy Information Agency, which uses that to forecast fuels, look at pricing. I'm sorry, could you repeat the question?
Sure. Alternative fuel pathways for fossil fuels would require refiners and distributors to disclose proprietary production, blending, and transportation information to avoid double counting. Correct?
I think they would definitely have to disclose it. Whether or not they chose to disclose it in a way that protected that confidential information would be a business decision, probably in the contracts for how to make and deliver the fuel.
And disclosing that information is important, right? Because without full transparency from all of these companies, there's not a good way to prevent double counting, right?
Correct, yes. If you want to do a fuel distribution system and provide an LCA, you would have to obtain that information from the fuel distributors and refiners.
We talked just a moment ago about Table 4 and its development being averages. If only one producer, such as Oxy, were to submit a custom pathway and all other refinery inputs are blended and unreported, the carbon intensity average would become mathematically meaningless, correct?
you have to define mathematically meaningless, but I think I get where you're going. You're trying to say that if you make an average and you take out something of the average, you change the average?
Yes.
Yes.
Are you aware that the fossil-based alternative fuel pathway is sometimes termed a poison pill to a low-carbon fuel program?
No, I was not aware of that.
In your rebuttal, you recommend the NMED adopt processing deadlines. I'm shifting to project credits for
Okay.
your benefit. In your rebuttal, you recommend the NMED adopt processing deadlines for 30 days for completeness review and 90 days for approval, correct?
So one clarification there would be 90 days for approval or notice. So the ask is 90 days to say whether the application was approved, or if it wasn't approved, notice of when they think it might be approved and some idea to a timeline. The idea of that request is simply to make sure that both the applicant and the reviewer respect each other's time.
And with the notice, I sincerely apologize about that, folks. With the notice, the only timeline that's permitted is a 90-day extension, correct?
I think that was the text that we obtained, I think from some of the similar air permitting rules. It was at the origin, but I think it may also be at the discretion of the agency. I'd have to double check.
I'll represent to you that the reading that I have of what the proposal contains is that the department would only have 210 days or 7 months to review and make a final determination on a project credit application. Given your understanding of the complexity of DAC to EOR, is that reasonable in your professional opinion?
Could you repeat the question, please?
Do you need me to repeat the representation as well?
No.
Is 210 days a reasonable amount of time to decide a DAC to EOR application, given the complexity of that process?
So I think it would depend on what portion of the project you were reviewing. In our experience, what I'll say is the portion that occurs on the surface can be reviewed in, say, 3 to 6 months. For the subsurface, where we've had similar projects which receive permits from either state governments such as California or federal governments such as the EPA and some of our Class 6 wells that we've done for our Stratos project. Those periods take much longer. I think we took 3 years to look at approving the subsurface program for the Class 6 wells. And now, given these were first of a kind in Texas, what we've seen is usually the first ones take the longest, and then they typically get shorter after that.
2 minutes, Ms. Sun.
Thank you, Madam Hearing Officer. And you've recognized that this proposal would be first of a kind for New Mexico, and yet you want them to this board to consider as reasonable, allowing only 7 months as flexibility to make a determination on something that you've just described can take years.
That's right. The idea to pull the language from the air permitting was just to have a reference and a place to start. I think we would be happy to negotiate those timelines and also to work with NMED on any protocols for subsurface sequestration or timelines for periods to review applications.
And you're aware that project credits would not just be DAC to EOR. It's not going to be just a one-size-fits-all approach, correct?
Correct.
And so it's your position that there must be hard and fast deadlines in this rule when the level of complexity of any project that could be proposed at this point is relatively unknown.
I don't think I would call it a 30-day period to see if an application is complete, and then a 90-day period for notice to be especially firm. But we do understand that there will be many projects that apply, and they will have complexities, and those timelines will change based on the project.
And are you aware that these proposals are the more stringent than even an alternative fuel pathway application?
For project crediting.
The project credit proposal is even more stringent than for alternative fuel pathway applications. Are you aware of that?
I think that's debatable.
Your testimony states that the department should, and the word you use is should, be allowed to consider approved protocols for similar project types. Do you recall that testimony?
Yes, I do.
Are you aware that in the rule language proposed, that recommendation comes in a clause that says shall consider?
Could you point me to the line?
It'd be page 41 of your exhibit that has the rule language. And do you see where you've highlighted the green?
I do. There's two sections, 25 through 27, and then 54 through 55. Are you referring to 54?
I believe it's the top one.
Okay.
And the prefatory instruction, is that regarding guidance?
Yes, I have here, consider protocols approved for similar projects developed by ICROA certified voluntary carbon standards.
So it's subsection B.
That's right.
In developing the protocols, the department shall. Do you see the word shall?
I do see the word shall.
Okay. And shall and should are very different, right?
I believe they are.
Thank you. Please wrap up, Ms. Sana.
Final question, Mr. Gray. The rule does not need to include liquid book and claim explicitly to allow Oxy to obtain innovative project credits, correct?
Under the project crediting pathway, I believe that is correct.
Thank you.
Thank you, Ms. Sona. Mr. Tucker, do you have any redirect?
Just a few.
Ms. Jones, could you put up the PowerPoint again? Good afternoon, Mr. Gray. You were asked some questions about Oxy's alternative fuel pathway proposal, specifically the choice between a fuel pathway and a project credit. Are there reasons why a company may want to choose to apply for a fuel pathway as opposed to a project credit?
Yes, they are. Primarily, it's driven by the economics of the market. So we've seen in other emissions crediting schemes internationally, such as ICROA, or excuse me, ICAO's CORSIA system, there is a large market disparity in the value of the carbon accounted on the fuel versus the value of the carbon counted on the credit. And so one of the things we've been looking to try and allow in these types of programs is to allow the flexibility for the operator to choose and help develop a market to support either one depending on the conditions of the market.
Are you aware of specific examples where there's a disparity in the price of the credits for a fuel versus just a project credit?
Yes, so specifically, for the example I just mentioned, in IKEA's Corcio program, the value of, say, a fuel made from used cooking oil, HEFA, sustainable aviation fuels, you're looking at a carbon price somewhere in the range of $400 to $500 a ton. When you look at the same programs they use on the voluntary basis, you're looking at a value in the range of somewhere between $5 and say $50 a ton. And so what we're seeing is this interesting disparity between markets being specifically kind of segmented for bio-based alternative fuels, where fossil fuels cannot compete. And so they're kind of forced into these other credit regimes where the price is very different. That may not be the exact case here in New Mexico, but it is something that we wanted the board to consider and understand that when you develop these markets, flexibility is extremely important to how those products develop and how that business case actually comes to fruition.
Thank you. I'd like you to turn to Oxy's alternative fuel pathway proposal. This is the slide on the screen shows Oxy's edit to section 205. Is it your understanding that Oxy's proposal restricts alternative fuels to only those using innovative methods or feedstocks?
Could you repeat the question there?
Sure, and maybe it's a little hard to see. Does Oxy's alternative fuel proposal restrict the alternative fuel pathway to fuels using innovative methods or innovative feedstock?
I believe it does.
And Oxy's proposal specifically lists two examples of innovative methods, direct air capture and carbon capture and sequestration, correct?
That's correct.
Okay. No further questions.
Thank you, Mr. Tucker. Mr. Gray, we're going to turn to the board members now. Member Ely, do you have questions of Mr. Gray?
Just one. On the DAC to EOR pathway that you described nicely, thank you. It doesn't tell me how you track the fuel that's being produced under this pathway, how you track its use in New Mexico. Do you know how much of that would come into the state for use by New Mexicans?
Yeah, so that would depend on a few things. So first, it would depend on where the crude is going to be traded on that given, say, production day. We'd probably do a month of production, batch that fuel. You need to get a contract between Oxy's production assets and the midstream company and the refinery who would use the fuel. It would then be set out in an agreement between those three players on how much crude was produced into that common system, where it was refined, and then of those refined products, how much of that was actually sold and distributed in New Mexico. We would be responsible for tracking that. And so it would most likely be done through probably an invoice or a mass balance accounting. I've also found it interesting, and this is a quick aside, let me know if this is too far. I've also found it interesting that the accounting systems I found in low carbon fuel systems, especially referring to book and claim, aren't actually book and claim, especially in New Mexico. I feel like what New Mexico has proposed is more of a book and claim / mass balance, when I look at chain of custody systems, there's usually a chain of custody system for complete physical separation, where you have a completely separate transport distribution system, and the identity of that thing is retained. In a commingled system, such as hydrocarbons, you're going to have, a system that's very much based on a fungible molecule. So you put molecules in, you take molecules out. And then the last system, which is book and claim, which typically has no physical connection. And then I just like to make the point that what we're proposing and what we're supporting is to have that physical connection for the pipeline and distribution systems into New Mexico. We have assets in the state. We produce enhanced oil recovery right outside of Hobbs, New Mexico. We're currently looking at innovative ways to potentially move CO2 from our projects in areas where we have atmospheric or anthropogenic CO2, transferring them through those pipeline systems that exist and getting them into the state.
That's all. Thank you.
Thank you. Madam Chair.
I think I'm good. I don't have any questions at this point.
All right. Thank you. Member Garcia.
No questions. Thank you.
Thank you. Member Hunker.
No questions. Thank you.
Thank you. Any reason not to excuse Mr. Gray? Thank you very much, Mr. Gray. Does Oxy have any other witnesses?
No other witnesses. Thank you.
All right. Thank you. Let's take, can we take a 10-minute break and come back? Because then we will break around 5. But I don't want to have to go all the way till 5 without a 10-minute break. 4:10. Faces in the front row. Hurrah. Let's see. So I think Mr. Maxwell, did I have you before or after before or after Sinclair?
Your Honor, are you asking if I have questions for a witness?
No, this is rebuttal presentation time. As I understand it, I have you in the lineup here before Sinclair.
I have no rebuttal. Thank you.
Thank you. So, Mr. Boutier and Mr. Harris.
Thank you, Madam Hearing Officer. HF Sinclair, and can you hear me? Am I speaking correctly? HF Sinclair does have one rebuttal witness, Michael Carr.
I don't need to swear you in again, but if you would spell your first and last name for the transcript, please.
You can probably hear me better now. Michael Carr, Michael-Caelcar.
Thank you so much.
Madam Hearing Officer, would you mind telling me when I have 5 minutes left?
I will do that.
Thank you. Mr. Carr, did you provide expert testimony several weeks ago in the direct technical testimony portion of this hearing?
Yes.
In your direct testimony, you described your background, training, education, and experience relevant to providing testimony in this matter. Is that correct?
Yes.
Did you previously describe what you had reviewed in advance of that direct testimony?
Yes, I did.
Since providing that direct testimony, have you had the opportunity to review any further and additional information Since providing that direct testimony, have you had the opportunity to review any further and additional information relevant to this matter in advance of your rebuttal testimony?
Yes.
Can you describe that information?
I can. Since my direct testimony, I have reviewed and evaluated the department's most recent proposed rule, 20.2.92, which was distributed by the department's counsel on October 24th, 2025. I have reviewed and evaluated the written rebuttal testimony and associated exhibits provided by the other parties in this matter, including NMAC's rebuttal exhibits. In addition, attended in person and/or reviewed the entirety of the board's September 22nd through October 3rd, 25 hearing in this matter, including the testimony of NMAD's expert witnesses.
Mr. Carr, based on that additional information, have you formed any rebuttal opinions or testimony in this matter?
I have. My rebuttal was described in detail in my written rebuttal testimony submitted in this matter.
Do you have any corrections or clarifications you'd like to make regarding that written testimony?
I do not.
Do you adopt your written testimony here in this hearing?
Yes.
Madam Hearing Officer, at this time I'd like to have admitted into the record Mr. Carr's written rebuttal testimony, which is attached as Exhibit A to H.F. Sinclair's Notice of Intent to present rebuttal testimony in this matter.
Let me pause for a moment in the event anyone objects.
Madam Hearing Officer,
Ms. Sona.
NMAD has an objection and also a oral motion to make regarding the testimony.
All righty, go ahead.
Thank you. I have 2 points to raise for the board regarding Mr. Carr's testimony. The first point is that Mr. Carr deliberately misrepresents information in his testimony. When the department fact-checked Mr. Carr's statements, it found that passages of the department's testimony were taken out of context and altered to support H.F. Sinclair's narrative. Specifically, Mr. Carr abused the testimony of Bureau Chief Borchert to claim it as a fact, when she in fact told counsel on cross-examination that the information was wrong and then declined to speculate. Words and sentences throughout the testimony, I apologize, let me back up. In the testimony, words and sentences with citations or talking about the law were put in quotes not to represent direct quotes, but supposedly to cast doubt or irony into their meaning. As a result, Mr. Carr's testimony lacks credibility and should be given no evidentiary weight other than his points of view. The board's regulation at 20.1.1.401A states that all testimony is taken under oath, and that I believe also that H.F. Sinclair should have an opportunity to withdraw the testimony that would cause the witness to violate his sworn duty to provide truthful and accurate statements. Regarding the second matter, Madam Hearing Officer, the department moves to exclude from admission in the record certain portions of Mr. Carr's rebuttal testimony regarding dyed diesel on page 13. This topic was never raised during the direct case in either the transcript or any party's testimony beyond Bureau Chief Borchert simply identifying it as an exemption, as existing in the rule. Moreover, Mr. Carr offers new substantive commentary on regulatory text that is not changed since the petition filing, meaning this could have been raised in H.F. Sinclair's direct case. The testimony is merely a new position by H.F. Sinclair and is not rebuttal testimony. Excluding the testimony is the only remedy consistent with the purposes expressed in your pre-hearing order and in 20.1.6D, C, and D, to ensure effective presentation of evidence and maintaining a fair and equitable hearing. Should any portion of the testimony be allowed into the record, even with a limiting instruction, the department requests that consistent with Section 302B, the record remain open should NMED decide it is necessary to respond with rebuttal to prevent procedural and substantive prejudice. Lastly, in anticipation that Exhibit B will be offered, and while I'm up here, I figure I should argue that one. The department is moving to exclude admission of H.F. Sinclair Rebuttal Exhibit B for failing to conform with your instructions on the exact same type of filing by NMOGA and API. The filing is premature as a statement of reasons redline, and the reasoning cannot be evidence because it constitutes technical testimony without a witness named for cross-examination. 41 reasons are provided in that document, which is much more than the few pages of Mr. Carr's testimony. This is particularly concerning because Mr. Carr's opinions have not changed since the direct case. If the reasoning is not excluded from admission, the department asks the board to give it the same instruction as before, which was for the board members to not rely on that document because it was premature. Thank you.
All right, thank you, Ms. Sona. Mr. Harris.
Yeah, thank you. First, I would like to just confirm that if the motion is denied and Mr. Carr is in fact allowed to testify, that this time is not going to be charged against him.
I stopped the clock.
Thank you. Appreciate that. To take the arguments in order, I think the first was with regard to fact checking. Or a statement or an argument that this was that Mr. Carr's testimony is somehow misrepresenting the testimony that was elicited at indirect. Although I can't tell you exactly what is being argued because, of course, there weren't any specific citations that were presented in this oral motion. I can tell you that I am confident that the citations are correct, but that, of course, the board can make that determination with regard to final arguments that are presented to it in final written presentation. With regard to the didiesel issue, didiesel, I think, was actually noted in the motion, in the oral motion, that it was raised as an issue, that it was raised in direct testimony by the department. It's therefore clearly an issue that can be addressed in rebuttal. It was also raised in the red line version that was presented to all parties after the hearing and after direct. So didiesel is an issue that can be raised in rebuttal. With regard to Exhibit B, which is the red line that was presented as part of the notice of intent, that was presented actually in direct response to former member Trujillo's request that we think that the board believes that a red line is the most valuable thing that it could get with regard to issues that any party has or suggestions that any party has with regard to a final rule. With regard to the motion itself, there's three main reasons and additional reasons why it should be denied. First, it's clearly untimely. Again, as with its previous motion, it was presented minutes before the testimony is presented, and that does not allow for either a full or fair response to the motion. It's clearly wrong. Every point and every last bit of Mr. Carr's testimony is directed to and is presented with a citation to the direct testimony that was presented. This is rebuttal testimony, and clearly rebuttal testimony, because it is Mr. Carr's testimony in response to rebutting direct testimony. And then finally, it's clearly yet another attempt, and I think a strange one, to try to prevent the board from getting all of the information that it needs to be able to craft a full and fair rule for the state of New Mexico. So I request that the motion be denied.
All right, thank you very much, Mr. Harris. Ms. Sona, I am going to deny the motion, but leave the record open for, leave an opportunity for you open to submit a surrebuttal or to put on a surrebuttal witness or other surrebuttal evidence as you feel necessary before we close the record. And to the extent the 41 reasons, I missed Vice Chair Trujillo, of course, but to the extent that looks more like a premature statement of reasons, I feel the same way. There's no particular harm in submitting it, but it's not evidence. It's just kind of an early preview of perhaps some proposed findings or conclusions you might later exhort the board to adopt.
Thank you. Again, the request was for Mr. Carr's written testimony to be admitted to the record.
Right.
Separate is Exhibit B was separate from his testimony.
No, okay, no, I understand.
Thank you.
And so to the extent, again, the department believes there are misrepresentations or other challenges in the testimony, I'd still like to hear the testimony, but I'm offering obviously the opportunity in Ms. Sona's discretion to submit rebuttal evidence to it. And the later exhibit, you haven't even offered it just quite yet. So we will accept Mr. Carr's testimony. We'll wait to see what happens with your 41 reasons, and we'll put you back on the clock. You were only 2 minutes in, so.
Thank you, Madam Hearing Officer. Mr. Carr, I see in your rebuttal testimony that you state that, quote, implementation of the Clean Transportation Fuels Program under a new rule should be through phases that ensure sufficient time is taken to achieve the goals of the Environmental Improvement Act. Did I read that correctly?
Yes.
Can you summarize the bases for that rebuttal opinion?
I can. In my direct expert testimony, I stated that to the extent that the department's staff are already devoted to implementation of many other important programs and priorities, and recognizing the department's finite amount of resources in this regard, it is my opinion that it would be prudent and pragmatic to implement the program in reasonable phases and thereby allow the department to understand the scope and challenges of the program in real-world circumstances before its actual enforcement. My opinions have not changed as a result of any information I received or testimony I heard in the direct testimony hearing in this matter. To the contrary, my original opinions were supported and reinforced by the information and testimony submitted during the direct testimony hearing. Indeed, the department expressly committed to implementing the program in phases, precisely because the department will struggle to implement the entirety of the program by its effective date. In my written rebuttal, I have listed the numerous specific statements made by the department regarding its inability to implement the program.
Mr. Carr, did any other testimony during the direct testimony phase of this hearing reconfirm your opinion that the program should be implemented in phases?
It did. In my original testimony, I also stated the department should follow the lead of other states implementing low carbon fuel programs that have taken a phased approach to implementation, because such an approach allows both regulators and stakeholders to adapt to the new system, which in turn ensures smoother compliance, better data quality, and more effective participation as the market is given the opportunity to establish a bank of credits for initial liquidity.
Mr. Carr, do you have a specific opinion about when and in what manner the program should be implemented?
I do. And it is my opinion that in light of the evidence presented in the direct testimony hearing, the effective and implementation dates of the program should be extended as follows. Program start on July 1st, 2026, with the remainder of 2026 being a reporting and pathway approval period only. The focus during this period would be to identify any information technology readiness issues, address any staffing issues, and certification of pathways that could be utilized beginning in 2027 for credit generators to allow them greater credit generation versus default pathway values. Credit generation would then begin on January 1st, 2027, deficit generation starting on January 1st, 2028, with an initial 2-year compliance period.
Mr. Carr, will the phasing you propose result in a delay of benefits of the program?
No, it will not. The department's own witness testified that credit generation from renewable fuels leads to immediate decarbonization due to the availability of credit banking as a compliance option. Mr. Drew's written testimony in Exhibit 76 on page 7 stated that, as I did in my direct, and that is correct.
Are there any other points regarding program implementation that you would like to make for the benefit of the board?
Yes. There have been a number of instances where NMED staff have spoken about the success of the Washington Clean Fuel Program. And indeed, it is true that that program has generated more credits than deficits in its early years. It is important to recall, though, that the program had an initial stringency of 0.5% and 1% respectively in its first 2 years, which is much lower than what is being proposed in this rule. Further, and importantly, the Washington Cap and Invest program that was initiated in 2023 in parallel to the CFP has an aggressive emission reduction trajectory that created a stronger compliance driver initially than the Washington CFP, making its targets what they call non-binding. Thus, the Cap and Invest program's stringency effectively pulled forward clean fuel adoption, leading to renewable fuel imports that far exceeded the CFP's modeled baseline for the same period. This phenomenon will not be in play in New Mexico, and making bold comparisons between the two programs should thus be avoided.
Mr. Carr, based on the information you received as a result of direct testimony hearing, did you develop an opinion regarding project-based crediting?
I did. Crediting opportunities for traditional fuels will be an important part of the proposed program. Given that traditional fuels are required to utilize a fixed carbon intensity pathway as per Table 4 in the new proposed rules, alternative means to recognize GHG reductions achieved in the traditional fuel supply chain are necessary for the program to meet the legislative requirement that it be technology neutral. It is my opinion that the board should implement project-based crediting on January 1st, 2027, consistent with the date that crediting would begin, based on the premises that the first 6-month period would be trial period only, as well as an opportunity to focus on any readiness gap, which is likely to be the case given the latter inclusion of project-based crediting into the program from its beginning.
Did you develop any other opinions on this subject based on the information you received during and after the direct testimony hearing?
Yes. With regard to the delineation of project types, I appreciate the department doing that in its October 24th, 2025 new proposed rule. It is my opinion that one additional category of project type that should be added to the rule would be innovative crude crediting. Innovative crude crediting, which exists in California's LCFS, is the production of crude using innovative methods that is refined into fuel used in New Mexico. Innovative crude crediting opportunities specific to New Mexico crude could be an especially important type of project crediting considering the upstream fuel assets located in this state. By adding an innovative crude crediting project type to the project-based crediting section of the rule, the department would incentivize fuel producers to further reduce the GHG emissions associated with upstream oil and gas activities.
Mr. Carr, did you develop any opinion regarding the credit clearance market based on the information you received during and after the direct testimony hearing?
Yes, the credit clearance market is an important feature of a program such as that being proposed by the department. In a stable market, the CCM, credit clearance market, provides a mechanism for a party that inadvertently did not acquire enough credits to find parties willing to sell credits and clear its shortfall. All states that have implemented these types of programs have such a feature, with the options for parties to voluntarily provide credits that can be purchased at or below a fixed price established in the regulation. However, the new proposed rule undermined the approach for voluntary provision of credits by dictating that any party that has more than 10% of the available credits in the market must make credits available for sale.
Is this approach problematic for a successful program?
Yes, it is. This is very problematic because it assumes that any party holding more than 10% of the available credits is doing so unnecessarily. Candidly, this assumption is terribly flawed. It would be logical that a large deficit generator that has more than 10% of the fuel market in the state could be holding more than 10% of the available credits for entirely appropriate reasons, especially if it is forecasting a shortfall of available credits and thus was banking credits as per the program for future compliance. Indeed, forcing such an entity to pledge credits undermines its ability to develop a robust compliance plan. Under a scenario where there is a, quote, short market in which credits are difficult to obtain, it is entirely probable that no such credits are available to replace them on the open market at any price. Under such conscription, the forced party would then have no path to compliance other than to sell less fuel or itself enter the CCM the following year and then suffer a 5% penalty when unable to obtain credits, giving it no advantage in the market despite its more thoughtful planning for compliance versus other parties. Additionally, the October 24th rule dictates any parties holding credits generated more than 5 years prior must make these available for sale. This provision is also inappropriately constraining on the market, even if it is an unlikely situation considering the realities of the market as proposed.
Do you have an opinion, therefore, regarding this provision in the new proposed rule?
Indeed, I do. It's my opinion it should be struck from any final rule along with the 10% provision previously discussed.
Mr. Carr, did you develop any opinion regarding the dyed diesel exemption based on the information you received during and after the direct testimony hearing?
Yes. It is important to exempt diesel uses beyond transportation in the program. It's a bit peculiar and again inconsistent with implementation of other clean fuel programs for this exemption to be time limited and applied only through 2028. All states with clean fuel programs make such exemptions in their programs, and these generally are not time limited. It is my opinion that the program and final rule should instead include important language updates that call out the appropriate exemptions and make them permanent by rule. End uses that are called out include farm vehicles, including tractors, construction vehicles, generators used at remote locations, or serving as backup power to critical facilities such as hospitals, emergency response facilities, and communications infrastructure. In addition to the above changes being wholly appropriate to ensure the final rule covers its intended scope of transportation fuels, it is also important to recognize that the program stringency proposed by the department ratchets up aggressively beginning in 2029. The timing of such an elimination of a dyed diesel exemption would be very problematic for the program and significantly increase the risk of credit shortages from the significantly greater quantity of fuel that would become obligated without these exemptions remaining in place.
Thank you, Mr. Carr. I appreciate it. I have no further questions this time, but I may have redirect.
Thank you very much. Yes. Let's start with the questions. Mr. Noyes, do you have questions of Mr. Carr?
Madam Hearing Officer, thank you. No questions at this time.
Thank you. I don't see Mr. Nasco. I don't think we've heard from Mr. Duff. Mr. Smith, do you have questions of Mr. Carr? Mr. DeSalen, do you have questions of Mr. Carr?
No questions, Madam Hearing Officer.
Thank you. He said no questions. Mr. Lobdell? Mr. Sorayas?
No questions, thank you.
Thank you. Ms. Vickers? She said no questions. I don't think we've seen Ms. Tremblay. Mr. Maxwell?
No questions.
Thank you. Mr. Weatherby? Okay. Mr. Tucker?
No questions.
He said no questions. Ms. Olson?
No questions.
She said no questions. And Mr. Molenberg? No questions. And Ms. Sona? Oh, good. All right. Ms. Sona, if you would just give me a second. Mr. Nasco, do you have questions of Mr. Carr? Mr. Nasco?
Thank you, Madam Hearing Officer. No questions.
Oh, terrific. Thank you.
Thank you.
I'm sorry I didn't realize you were on the platform.
No, that's okay. No worries. Thank you so much.
All right. We'll go to Ms. Sona.
Thank you. Hello, Mr. Carr.
Good afternoon.
I want to get us started with a clarification. So you attributed a number of your statements to rule language in the department's October 24th discussion draft. Do you recall that?
Yes, that was the latest version you provided to provide red lines with.
Okay. And it's correct that the department made no changes to the credit clearance market provisions or to the dyed fueled provisions in that draft, correct?
Unfortunately, no, they did not.
Okay. You state that the department, in your oral presentation today, that the department committed to implementing the rule in phases. Do you recall that?
Yes,
Were you present during Dr. Rasso's testimony during the first 2 weeks of the hearing?
I was.
Do you recall her extensively stating that the department was not implementing the program in phases?
Dr. Rasso described that certain pathways may be deprioritized, certain pathways might happen sooner than others. There was very much indication from what I heard in her testimony that there was, if not in rule, certainly in practice, going to be prioritization and the need to pace the work, significant workload. Let's not underestimate. They've got a huge task in front of them to stand this program up. That they would have to pick their battles and prioritize, and that sounds a lot like phasing to me.
Okay, but do you recall that Dr. Rasso explicitly rejected the use of the term phasing due to its connotation for step-based approach that was being proposed by H.F. Sinclair?
It seems like we're talking semantics here. I'm not going to dispute what you claim Dr. Rasso has said.
Okay. In your recollection, is it correct that the department never testified that it could not implement the program?
The department seems quite confident. There have been witnesses who have seen the real world situation where you're standing up a program like this and you've got to expect the unexpected. There's certainly evidentiary outcomes in Washington where it was almost 2 years before they started accepting pathway applications. They had IT issues. I think you'll recall Dr. Rensing also said in his testimony that expect IT problems. There will be issues, and giving yourself the space to deal with those sort of issues, laying out a deliberate start to the program is actually wise and should be attractive to both to all parties involved.
And to that end, what H.F. Sinclair is proposing is that deficit generation would not begin until January 1, 2028, with the first compliance reports being due April of 2030, correct?
That's correct.
Under this proposal, New Mexico would enter the year mandated for a 20% reduction before anyone would be required to demonstrate compliance in the system. That's what you're proposing, correct?
So credit generators would be generating credits beginning in 2027. Banks would be formed. I think the department would have visibility of those banks, and you would settle the accounts in 2030. So yes.
So to be clear, though, there would be no picture of settling the accounts until 4 to 5 months into 2030,
I
correct?
think it's April 30th. So yeah, 4 months into 2030.
Okay. You testified extensively regarding the credit clearance market. And I just want to make sure we're on the same page with this, that you understand the purpose of the CCM is to ensure that regulated parties have access to the credits necessary for compliance at the time compliance must be demonstrated, right?
Correct.
Okay. And you also understand that the CCM process in the rule does not begin with mandatory pledging, but it begins with voluntary pledging, correct?
It begins with voluntary pledging, but then moves to conscripted pledging if there's an inadequate quantity of credits provided voluntarily, which would be the shortage market, not the, oops, I forgot to get 50 credits, I need the CCM open for that. It's the market is struggling, and that's when that could come into play.
And so the mandatory pledging provisions, if triggered, you agree then serve the role of preventing a potential market failure.
They do. If somebody has a third of the market, it would seem strange that they would be forced to give away those credits that they need for compliance for the sake of another party that did not do their homework.
You're aware that pledging is required for the credits not being used to demonstrate compliance, right?
So if a party is holding credits for the next compliance year because they see a shortage going forward and they have more than 10% of the market and that was their compliance plan, the CCM provisions as they exist undermine the ability for that plan to be implemented by that party. So it might be good for the department, but it might not be good for a party that has done its homework and laid out its compliance plan and holds those in the bank for the next compliance year.
But it's not going to be good for the market because failing to pledge those could collapse the market, correct? That's what you just stated.
Well, let's put it this way. If you get to that point, the market's in trouble already, and you probably need to be looking at your authority to defer. But you are playing winners and losers under that scenario. So you are at that point willing to sacrifice someone who's done their work to the benefit of the market. But that's what the current regulation, as I assess it, would do.
And so you agree there is additional protections in the rule, such as forecast deferrals, that could be utilized in certain situations. The credit clearance market isn't the only option, right?
Under New Mexico's program, there are additional methodologies.
Okay. I want to turn to the portion of your testimony where you talk about what Mr. Drews has said.
Mm-hmm.
And you cite his testimony to argue that delaying the start of crediting under your proposal would not delay benefits, correct?
I said delaying surrender of credits to satisfy a deficit obligation would not compromise the benefits of the program because the benefits arise when the renewable diesel lands in the state and gets combusted. So if it gets combusted January 2nd, 2027, the state has seen that benefit from the beginning. So that's what I was speaking to. It's around, you put it in a bank or do you surrender it? It still happened. The benefit has still been achieved.
So you disagree that this sentence was plucked out of context when it was written in the context of what the department's rule would do, not what H.F. Sinclair's rule would do.
I'm not aligned with that assertion. At the end of the day, what H.F. Sinclair might choose to do within the context of the rule would be consistent with what Mr. Drew said in his testimony.
So you agree that nowhere in Mr. Drew's testimony does it state that delayed crediting provides the same benefits as immediate crediting?
Again, we are saying crediting beginning in January 1st, 2027. And if deficits don't incur until 2028 and folks are banking credits, then the benefits of crediting are taking place.
The department's proposal is for crediting to begin on April 1, 2026, correct?
Yes.
And January 1, 2027 is months after that, correct?
Correct.
So H.F. Sinclair's proposed credit and deficit generation timelines, under those timelines, it's not possible to get the same types of decarbonization benefits as under the department's proposal, correct?
It really depends. If there was experience in Washington where it was very limited credit generation for the first few months. So what we're proposing is get pathways approved, let folks get the maximum amount of credits. If you have 0% deficits a 0% CI reduction in 2027, you create a huge driver for folks to say, I've got a pathway that gives me a lower CI score than what's in the tables. And in fact, the tables per the last discussions are getting more conservative. So that means the crediting is even less. Get better CI scores approved in pathways. The maximum credit generation, it was pointed out in one of the testimonies that at a 1.8% reduction or 3.3, whatever year you're looking at, that creates a greater credit opportunity versus future years. Well, zero's even more. So in terms of setting your stall out as the new store in town, provide the maximum incentive by getting alternate pathways approved in 2026, letting maximum credit generation occur in 2027. I think that's the best way to open the floodgates and really see credits coming into this state.
Mr. Carr, you have no modeling attached to your testimony filed in this record, correct?
I have no modeling.
And in fact, your testimony criticizes NMED's reliance on Washington as an example due to the Cap and Invest program existing in Washington, right?
Absolutely.
So it's not credible to say that we should look to Washington for this.
I'm not sure I follow your question. I think Washington is a very important example to have a look at. You know, again, Washington was 0.5% in 2023, 1% in 2024. At the same time, the Cap and Invest program was asking for 7% a year, which was an incredible vacuum that pulled significant quantities of fuel and actually overwhelmed the CFP. I don't need a model to see that outcome. I actually would say I appreciate Mr. Drew, you know, the modeling work that you did that we got visibility of recently. I actually thought that was very good and helpful and appreciated that was done. And I think that sounds like that's going to be something potentially discussed a bit further, but I was very pleased that was done and thought it was done well.
Thank you. I'm sure Mr. Drews will appreciate hearing that. Speaking of the Washington Cap and Invest program, your testimony doesn't have any citations or academic studies to support what you say. And so all we can rely on today, right, is your perspective on what you perceive.
Today you have my testimony.
You have 2 minutes, Ms. Sun.
Thank you, Madam Hearing Officer. Just checking, Mr. Carr. I think we covered a lot of it.
Good.
Thank you. Appreciate your time. I have no further questions, Madam Hearing Officer.
Thank you, Ms. Zona. Mr. Harris?
Very few questions.
All righty.
Thank you.
Mr. Carr, I have just a couple of questions in redirect.
Yes, sir.
In her cross, Ms. Sona asked you questions about Dr. Rasso's testimony and whether or not she had testified that the program should be implemented in phases. Do you remember those questions?
I do.
Okay. And I'm going to read from your written testimony, your written rebuttal, where you stated, sorry.
Finish your question. I'm sorry.
Sure. Where you state that Dr. Rasso testified that the department advocates a multi-phased implementation approach because of the complexity of the program the department has proposed. Quote, and you quote here, and you're quoting from Exhibit 67 to the department's NOI, and that's Dr. Rasso's testimony. Quote, we, the department, have deliberately scoped the program's rule to enable phased implementation, prioritizing the most critical components and allow for the shortest possible delays in components of the rule as phase one, and addressing the more difficult to administer components, such as alternative fuel pathways, applications, project credits, and dyed off-road diesel reporting requirements in subsequent phases. Did I read that correctly?
You did.
Thank you. That's all the questions that I have.
All right. Thank you very much, Mr. Harris. Member Ely.
No questions?
Thank you, Madam Chair.
No questions.
Member Garcia.
No questions, thank you.
Thank you. Member Honker. You may have stepped away. All right. Is there any reason not to excuse Mr. Carr? No. Thank you very much, Mr. Carr. Wow, we made it exactly to 5 p.m. Who will our first witness or two be in the morning? Just heads up.
I apologize.
Our first witness is in the morning. So it'd be Namoga, presumably.
Yes, Madam Hearing Officer, we'll be ready to go first thing in the morning with Dr. Rensing and Ms. Losey.
Thank you very much.
And then I believe probably where we're at is we'll have to fit Dr. Schubert's surrebuttal testimony in a bit later. I'm not sure whether we'll get that filed tonight or not. We're going to try to. And if folks are okay, we could probably put him on directly after. I think he's generally available tomorrow.
All right. Terrific. All right. Well, that'll do us for a start in the morning. So thank you all very much. We'll see you at 9 o'clock. Well, we'll see you at 6 p.m. if you come on, and then 9 in the morning back in the room.